Recording content.
Okay, good morning. And Ashley, could you just put in the thumb drive so we can make sure we can forward the. Good morning, everyone. My name is Steve Buckley. I'm your legal services counsel for the New Hampshire Municipal Association. And I'm joined today off camera by Jonathan Cowal, our Municipal Services Counsel. We're both making this presentation to you today on the right to know law, governmental meetings and records. This is a hybrid workshop. And I should be able to forward this. You might have to take that out and put it in again,
Sure.
Ashley. And wait 1 second, because we've got a lot of interactive technology that has to work in sync with each other. And no.
Yeah.
Was there nothing, anything else? Try it again. As we try to get this synced up. Try this one. Just wait a second as we try to get everything moving in the right direction. Pardon us out there who are watching us virtually. Okay, actually, you're going to have to forward.
Sure.
Yeah. So next slide.
Well, you think the arrow
There we go.
would allow me to do it, but it didn't.
What do you have to use?
I have to use my mouse and use the arrow at the bottom. See where it is right there?
Okay.
Yeah.
So pardon us for that brief interlude as we tried to get all this technology working smoothly together. Again, my name is Steve Buckley, Legal Services Counsel, and I'm joined today by Jonathan Cowal, our Municipal Services Counsel. And today's presentation is the right to know law, governmental meetings, and public records or governmental records. Next slide. We always take a moment at all of our presentations to give everyone an introduction to the NHMA Legal Services Group. The two of us, Jonathan and myself, constitute the NHMA Legal Services advisory services for NHMA, and just always want to make sure you're aware of how you can use our services. We're available by email at legalinquiries@nhmunicipal.org. And you can also call us at 603-224-7447 to ask us questions. We do try to get a response back to you within 48 hours. Sometimes we're a little slower based upon the busyness of the year, but we do try to provide you what our job is to give you essential legal advice on issues facing your municipality or issues facing you as an elected or appointed official. Some of the things that I just feel it's important to remind everyone that we are not really able to give you a comprehensive legal review of documents, and we're really not able to write or draft ordinances or bylaws and give you a legal review of those. We do try to give you, because we get a lot of questions on land use matters, we try to give you kind of the best guidance we can on a pending application with the ZBA or the planning board, but we really can't tell you how to make the decision whether to grant the variance or approve the site plan. And we really do try to ultimately stay out of disputes between the select board, the library trustees, and other boards and commissions. We really don't think that's our role or responsibility. And again, our goal is to get a response to you as quickly as possible, sometimes right away if you get us on the phone right away, but typically within 48 hours. Next slide, please.
You want to give me the clicker? I'll see if I can fix it.
Okay. Part of the materials you received today is our electronic publication, the New Hampshire's Right to Know Law. We updated this publication in 2021. And a few things in the publication, I just want to remind you as an asset you have at your desktop. It's a PDF, so you just load it on your desktop, which you would have gotten today. And then you can access the information. You might quickly be able to get answers to some of the vexing questions you have under the right to know law. But in particular, is it working out? Okay. Great. In particular, the publication has a number of contents that, bear some close attention. Number one, we have a glossary that gives you an insight to specific content and information that direct you to, a particular question you might have. You can go to the glossary. We also have a remote participation checklist. Some of you may know that there is a method of having public body members participate remotely, so as long as you have a quorum of the public body in the physical location of the meeting. So we have a checklist you can follow. We have a non-public session checklist, a checklist you can use to then do a step-by-step correct procedure to enter and exit and keep minutes of a non-public session. We also have a law enforcement guidance, a complete copy of the right to know law, and a complete copy of the retention statute, a table of cases, and a table of statutes, all which contain hyperlinks. So you can go to a hyperlink, you can go to the table of cases, and or you can go to the table of statutes, and you can link to the content of the book that describes that particular case or statute. So it's a very helpful and I think usable electronic tool that you should access and use in the daily business of being in local government, which very much is dependent upon compliance with the right to know law. So our agenda today is in two parts. The first part is my part. I'm going to be addressing governmental meetings and the right to know law in non-public sessions. And then Jonathan will pick up on governmental records and the right to know law, record retention, and remedies. What we plan to do, because this program will go to 1 o'clock, I'm going to be speaking roughly until about 10 minutes to 11. And if we do this correctly, we'll be able to then transition after a 10-minute break to Jonathan and conclude at 1 o'clock. And just so you know, after the program is completed, you'll get another email from Ashley, and she will send you a copy of the materials again, which is everyone got a copy of the PowerPoint presentation, as well as another copy of the publication. And then you'll also get a YouTube link to the recording of this program, and that will be available to you, so you can share that with your other municipal colleagues. So for those who are attending virtually, you should know how you will be able to submit inquiries to us today. So the method that you should employ, or the only method available to you who are participating remotely, is to use the Q&A. So please locate the toolbar for the Zoom program you're using, and you should click on the Q&A. And in the Q&A, you will be able to post questions. Now, we're not going to type answers to those questions, even though that's what the slide says. What we're going to do is Jonathan is going to read out questions to me during the program, and I will answer them verbally. And then we'll also answer questions, of course, from anyone in the room here. So that will all be picked up, I hope, by everyone on the microphone system here, so you can hear our answers and receive very particular advice on particular questions you may have on the right to know law. So start with your questions in the Q&A function if you're participating virtually in the Zoom program. So let's get into the business of governmental meetings and the right to know law. What we're going to cover today are, amongst other topics, is what is a meeting and how do we run those meetings effectively. What is not a meeting? That is, there are things that take place that are not covered by the right to know law. They're called non-meetings. Not a great word, but that's what we employ, because then separately from non-meetings, we have things called non-public sessions, where a public body can convene when it's in a meeting in a session where the public is not allowed to attend. We'll cover that in more detail. And then finally, we'll talk about the requirements of holding proper meetings and also how we use some of the tools to have programs presented virtually, or how members of the public might be able to participate, or one member or two, perhaps two, of a public body can participate virtually in programming or a public meeting. The starting point whenever we present on this topic of the right to know law is to understand the duties that we have as public officials. It's not just statutory, it's based upon the New Hampshire Constitution. And the language of the New Hampshire Constitution ended up being borrowed very significantly and completely when the statute was written. But it's important to understand, because it's a constitutional obligation, the courts are particularly demanding and requiring strict compliance with the language of the statute because it's a constitutionally based right. And the things that the Constitution says must be the case is that government has to be open, accessible, accountable, and responsive. And therefore, as the Constitution says, the right of the public access to governmental proceedings and records, so proceedings and records, and that's how we've divided up this program today, proceedings, meetings, records, public records, shall not be unreasonably restricted. And so when the right to know law was written, it incorporated some of those same concepts. The purpose of the statute, RSA 91-A, is to ensure the greatest possible public access to actions, discussions, and records of public bodies, and making sure that government, local government, all levels of government is accountable to the people. So what's a public meeting? It's important always to be cognizant when a meeting does exist and then triggering the obligations to comply with the right to know law. So a meeting, in short, and we'll cover all these terms in more detail, is a quorum of a public body that convenes so that all the members can contemporaneously communicate with each other, which, by the way, can occur by email or by chat or by telephone conference. All of those are means by which a public body can be convening together, if it's a quorum, to discuss or act upon something over which that public body has supervision, control, jurisdiction, or advisory power. A couple of pieces of advice that we have seen over the years, and some of this information has started some time ago as these issues bubble up and are addressed by either those who have kind of supervisory jurisdiction over the right to know law or go to the courts. One thing I would mention is the New Hampshire Attorney General's office has in many ways been seen as an important resource for understanding what are the duties of government to comply with the right to know law. And sometimes the Attorney General's office issues formal written opinions, which you can actually access on their website. What they did issue one particular opinion that is guidance on this particular issue of what is a public meeting. It was concerning public meetings that were being held by the Department of Transportation. I don't know what exactly the public meeting was, but I don't know, those of you who are familiar with some of the things that really are important to local government is the 10-year transportation plan. And as the 10-year transportation plan gets eventually approved, the TIPs the transportation improvement plans are approved at the local level for the regional planning commissions. And then there are meetings held by GAS at the governments, the government and governor and council and transportation group. They have meetings to decide what will go into the 10-year plan in terms of improvements to public highways. So apparently back in 1993, the Department of Transportation was holding these meetings without notifying the public. They were going to have these public meetings on the 10-year transportation plan, and the Attorney General's office had to warn them, no, anytime the Department of Transportation has a meeting and it's a public informational meeting, they have to comply with the right to know law. And I will point out later on, there isn't a lot that goes into the duty to comply with the right to know law, other than the public has to attend, you have to notify the public, and you have to keep minutes. Those are the three basic requirements. And the notice requirement really isn't that difficult. You just have to put notice in 2 public places 24 hours before the meeting. And by the way, you never have to post an agenda for a public meeting. I'm not saying you shouldn't post an agenda for a public meeting. I'm just saying you're not required to. You just have to notify the public 24 hours before the meeting in 2 public places, one of which could be your website. So I think, the fact that the Department of Transportation at that time was not doing that probably wasn't advisable, and they had to be reminded by the Attorney General's office. When that agency holds public meetings, it has to notify the public in compliance with the right to know law. And then another interesting case that came down in the Superior a couple of years ago was a situation where the boards of selectmen of Marlborough, Dublin, Harrisville, and Nelson, they were having combined meetings of the select boards because they were trying to figure out how we would cooperatively put together probably an intermunicipal agreement to run a transfer station that all of those towns would have the benefit of. And so they were having these meetings without notifying the public and without allowing the public to attend. And a Superior Court judge had to say, no, you can't do that. You've got, in each instance, there were these combined meetings of those select boards, and there were quorums of those select boards meeting. And just a reminder that, you know, those were public business. Now, I suppose those select boards thought, well, this isn't really directly the business of my town. It's a multiple town decision-making and discussion. And so clearly, of course, when local government is dealing with issues such as waste management, that's government business, and that has to be the kind of thing has to be discussed at public meetings. So a quorum of a public body that convenes to have the members contemporaneously discuss with each other to act on public business is in fact a public meeting, and the right to know law attaches. So what's a quorum? A quorum is always a majority of the public body. Now, one of the areas that we've had a lot of questions about recently is, and a lot of towns have these advisory committees, and sometimes it's a little tricky to determine, well, what is the membership of this advisory committee, and then when does a quorum exist? And I would just say on that topic right now, if your select board or town council or whoever it is going to establish an advisory committee and assign them some duty to assist the select board or the town council or the city council, please be sure that their motion of creating that advisory committee defines the membership, how many, so that you won't have any question in your mind, when do we have the quorum requirement to have public meetings? And you certainly cannot ever define the quorum of a public body as less than a majority. On the other hand, there are lots of communities, I know Hooksett is one, and some city councils have these as charter requirements. I know in Hooksett they have a charter requirement that says when the town council is going to convene for a public meeting, they have to have 2/3 of the members present, not a majority. Now, even if there was less than 2/3 present, that would still be a public meeting. But under Hooksett's charter, there's a 2/3 requirement for membership of those who are attending in order to do public business. And that's not an uncommon requirement in some city charters to have some higher level of attendance for certain activities. I know, for instance, if you want to override a city budget, you have to have a 2/3 vote in favor of supermajority. And there are sometimes occasions when other statutes dictate a certain number of people have to be in attendance. So those of you who are familiar with the business of a zoning board of adjustment, there's a statute that says there always have to be 3 members of the ZBA who are present in order to act on approving some kind of relief granted on the zoning board of adjustment. But I suppose you could have 4 members present. You still have a majority present. There's certainly more than 3. But that if there was a tie vote 2-2, they couldn't take final action because you have to have 3 concurring votes for a zoning board of adjustment. So always keep in mind that there could be other statutes that come into play and might define an obligation of a higher amount of people have to attend to take on certain business. But with regards to the right to know law, it's always the majority. And I see that there's a question.
I don't have one.
I have one on mine. Do you have it up? Okay. So I have a question here. I understand that the access aspect of the right to know law, but what about someone disclosing items discussed in non-public meetings where the minutes are sealed? Say an item under reputation of someone who's not a member of that body. Would this be a breach of an oath of office? Who has standing to swear a complaint? Okay, Jim, I see your question. I'm going to hold that question until we get to non-public sessions. But yes, there is a statute. It's RSA 42:1-A that does say that if you disclose information from a non-public session when you knew or should have known it would cause harm to someone's reputation, that could be a basis for a petition to the Superior Court to have you removed from office. So that is true, but let's hold that detailed addressing that issue when we get to non-public sessions. Then I have another question. What about records committee? Are there public meetings? You always hear that there are non-public because of confidentiality. So that's VASCO. So if a town has, there's a statute that governs retention of records, RSA 33-A, and that statute does contemplate, I think it's section 1 or 2, then a municipality should have a municipal records committee. That's going to be a public body, and that municipal records committee is going to require to have its meetings in public. But certainly there could be circumstances where the public body is going to have a discussion on something that would touch on a non-public session. And that public body could go into non-public session. So and we'll get to this a little bit later on, but there is a new provision that, let's assume the records committee was considering, which would be unusual, addressing the content of non-public meeting minutes. Normally that's done by a public body itself, but there's a new provision that allows a public body to go into non-public session for the purpose of deciding whether or not we should unseal previously sealed non-public meeting minutes. So that does exist as a provision. Then we have another question. If there is a public meeting with a quorum present, but during that meeting, one member needs to recuse himself due to a conflict of interest on a particular issue, can that meeting continue? Can a vote be taken on the issue of that member recusing himself? So that's a good question. If there's no longer a quorum of the public body present, there's no longer a public meeting, the public body cannot conduct any business. So if you're in the unusual circumstance where a member has to recuse themselves, and now that depletes the ability of the body to then have a quorum, then there isn't a meeting anymore. And I think that you need to take steps to be prepared for those circumstances. If you're a land use board, you might be able to appoint an alternate. Select boards and governing bodies don't have alternates. If you don't have the ability to appoint an alternate, it may be necessary to adjourn that meeting. That's really the only approach that you can take with regards to that. Just again, to complete the thought about quorum, it's always a majority of the member of a public body. And again, I just would encourage public bodies, when they, especially select boards, establish advisory committees, please state in the motion establishing the advisory committee the number of members, so there's no question as what constitutes a quorum for public body meeting requirements. Public body is pretty much anything statutorily defined, either the legislative body, governing body, board, commission, committee, or any other county, town, municipal corporation, etc. It's any committee and subcommittee or advisory committee, and that's important to understand because this advisory committee part sometimes trips municipalities up. And in fact, there's a Supreme Court case addressed this that turned into an amendment to the right to know law, Bradbury versus Shaw, that actually involved the city of Concord, where the city of Concord's mayor had created an advisory committee of local business people he was using to help him develop industrial capacity and bring about industrial development in the city. And a local newspaper, probably the Concord Monitor, said they wanted access to the minutes of the meeting. The mayor said no, and the Supreme Court eventually said you can't do that. And eventually the legislation was amended to make clear that an advisory committee means any committee, council, commission, or other body whose primary purpose is to consider an issue or issues designated by the appointing authority. And that's a very common thing. And most of the municipalities that we work with all typically have advisory committees that do work for the public body. But a very interesting case, by contrast, which it gives you some understanding of what is and what is not an advisory committee subject to the right to know law, was the Martin versus Rochester case. And it's worth pointing out what happened there. That was the situation where the city, and many of the cities have these committees, they create technical advisory groups that are made up of department heads whose job it is to give feedback to a site plan applicant, someone who wants to do some kind of industrial commercial development. So they convene these meetings with the sewer department, the water department, public works department, fire, police. They send someone to these committee meetings. Someone comes in and says, I want to put in a Walmart in this location. What do you think? Tell me what are the issues I have to address. And that's what the city of Rochester had. And there was someone who insisted that that person be able to attend that meeting. And the city said no. And in part, the city said, this advisory group is not there, as the statute eventually says, is for the purpose of providing advice or recommendations to the planning board. The advice or recommendations were only going to the applicant. So you would meet with these department heads and the applicant would then know, how do I put my application together to get it approved? And the Supreme Court said, technical advisory group that is not directly advising the planning board is not a public body. And so you're not entitled to attend that meeting, and that meeting, the minutes of that meeting, they didn't keep them. They only gave advice directly and sometimes in writing to the applicant. It was not subject to the right to know all. Yes.
So if they didn't give it to the applicant, but they gave it to the boards themselves, then it would be an official committee and it would require to have minutes of that meeting.
Correct. And that's the distinctive characteristic, and that's in fact what the definition of advisory committee is. If it is providing advice, input, guidance to the appointing authority, then it would be a public body, would have to have public meetings, want the public attend and keep minutes, et cetera. That's correct. So the manner of discussing, that is the convening, is another element of the definition of what's a public body and then what is a public meeting. So it's not just that there's a quorum meeting together, but they're convening so that the members can communicate with each other contemporaneously. If you're all in the same room, that's easy to understand. However, it gets a little trickier to understand, I suppose, when you're dealing with a chat room or texting or other forms of electronic communication. Clearly, if all the members of a governing body or a quorum of a governing body are texting each other on a group chat on a particular issue of public business, that's a public meeting in violation of the right to know law, because the public can't attend that meeting. The same thing is true with emails. If a member of the public body sends an email to all the other members and all the other members can hit reply all and begin a continuous communication and discussion on any particular topic, that is also a contemporaneous communication, but then it also violates the right to know law because the public can't attend there. So what we try to make sure people to understand, we're not saying you can't use email. So it's okay to use email, but there are some limitations. You could send an email to a quorum of a public body, so long as you, number one, send it using the blind CC method, so that you don't put the email addresses of the recipients in the to section or the CC section. It goes into the BCC section of your email program. So when you send it out, the person gets it, they can't hit reply all and send it back to everyone else. It only goes back to the sender. So that eliminates that kind of back and forth discussion. The other thing which is okay, this is really designed to avoid substantive discussions taking place among some members of a public body that are based on the things that they do, the public business they're conducting. Doesn't mean you can't send an email to the entire public body. As an example, there's been a snowstorm, the chair of the ZBA needs to cancel the meeting, the chair of the ZBA needs to send the email to all the members saying, we've got to cancel the meeting tonight, please confirm you got this email. And even people just send an email saying confirm. That's okay, because it's not a substantive communication. It's designed to deal with very minor administrative matters. But generally speaking, using the blind CC method is really the better way to go. The other thing that I think, I would mention about the manner of using electronic communications, especially the convening part, is, and I'll just skip to the next slide. As I've said, you really should avoid as much as possible some of the discussions via email, because it circumvents the spirit and intent of the statute. And really, if we could, I'd like to remove the reply all button from all email programs if I could, but I can't. And just keep in mind that all emails are governmental records. There's one particular part of the statute that I always feel is useful to read, and it's RSA 91-A:2-A. And what it says is as follows: communications outside a meeting, including but not limited to sequential communications amongst a member of a public body, shall not be used to circumvent the spirit and purpose of this chapter. So how could that occur? Well, you've got one member of the select board texts member A, text member B, and it says, we should do the following. Why don't you text member C and say the same thing? Oh, member B then text member C. We should do the following. Okay, fine, let's all do that. And now you've had a sequential communication amongst 3 members of a select board who have just made a decision. Now they're then going to come to the meeting and they'll, without any discussion, say, let's vote to grant or deny a particular application for tax abatement. And the public has no idea how they reached that decision because they did it sequentially via text. And that would be clearly in violation of the right to know law. Do have a couple more questions here. How does public meeting requirements, presumably, how does this apply if a planning board member posts on Facebook and 3+ members see it or comment on it? Yeah, if you've got, first of all, I really would encourage members of a land use board to stay off social media. It's not the place to conduct public business, and that's not a good place to be, especially, and there's a case right on point here. If someone sets up a Facebook page specifically to oppose that new Walmart in town, and you all join that Facebook page as a member of as a member of the planning board and start posting messages and content opposing or supporting the project, you've got major problems with your conflicts of interest and prejudgment. So just please don't do that. It's not a good idea. And I know that a lot of towns, I know we have it in my town, we have the neighborhood Facebook page and everyone posts stuff. That's fine. But if you have a situation where, as this particular person asks, if you've got 3 planning board members who are on the Town of Bow Facebook page, it's not a public Facebook page, it's a private one, and they start exchanging messages on public business, you've got a problem. And it's got a problem because that could be considered a convening of the membership of a land use board. So if you had, in this instance, we have 3+, so if it's a 7-member land use board, planning board, you've got 7 members of the planning board, and there's 4 of you going back and forth about a pending Walmart project in your community, that's an illegal convening and it should not be done. Next question I have here is, did I hear correctly, a body advising a town board or committee should keep minutes of their meetings? We'll get to that in a second, but if there is an advisory committee of a community that has been assigned the task of assisting the select board, my wife was on a committee of the select board that was created in my town to advise the select board on how to harmonize all of the town's signs to make them look aesthetically pleasing, and they were developing standards for sign aesthetics in the town, and they had meetings for 6 or 9 months, as I recall, and they came back with a report to the select board. That's an advisory committee assigned the duty of providing advice to the select board, and that is a public body and would be required to keep minutes. Yeah, I'm just going to make sure I don't have any more questions here. One more question here is, a right to know request comes in via email. Does it go to your junk box, but you are unaware of it until the sender calls someone afterward? It has been sent. How should that be handled? I'm going to let Jonathan tee that one up later on, because that's really going to come under governmental records. I have a very difficult time sometimes using my keyboard mouse on my machine. I hate doing it.
So Jonathan, unfortunately, is having a little bit of issues with the questions. Do you want me to read them out loud, Steve?
No, I got it.
Okay.
And the next one I have here is setting a meeting date by email okay? Yes, that's probably the kind of administrative activity which is certainly reasonable for a public body to do, without all the formalities of a public meeting. Hold on a second while I drag this stuff down.
I'm trying to, as you answer them, I'm trying to mark them as done and get rid of them for you.
Assuming the email sender used reply all. Hold on a second. Beverly's got a 2-part question. Would pass along the pricing for an expenditure be considered a public meeting using email, is that sufficiently substantial? Yes, don't do that. Assuming the email is sent reply all, yeah, don't do that. You could, I mean, you could, if you're a select board, I suppose, what you could do is, let's say in the next select board meeting, you're gonna have to discuss approving an RFP or a purchase. And between the last meeting and the next meeting, the town administrator get all these price proposals for your consideration. It's okay for the town administrator to send you a packet of information for the members to think about. So when they get to the public meeting, they can make the choice, but it's not the members themselves trading information back and forth about prices. It is, you know, a packet of information that's going to be considered at the next public meeting. Okay, so another interesting question. Two selectmen sit as members of a communication district, not discussing their town business, but business of the communication district. Is this a quorum of the selectmen that requires posting in the town they serve? Great question. So if a quorum of a public body is present because they're at the meeting of another public body, and they're there for the purpose of attending that meeting, but not for the purpose of conducting select board meeting business. So they're at the meeting of this communication district. Those of you may know RSA 53-G, I believe it's correct, has this new provision where communities can band together, create communication districts for deploying broadband, and they're made up of member communities. It's kind of like an intergovernmental agreement. So if you've got two members of the select board sitting as a member of this communications district, just because they're now a quorum of that select board at this meeting of another public body, but they're not conducting public business of the select board, they just happen to be there. That doesn't make that also a meeting of the select board. They just have to really avoid conducting select board business. That's really a key part of that. And then I'll do one more and I'm going to continue on. Say a new member joined a planning board and attended the first meeting as a member and took a certain position on an issue. Will another senior member of the planning board contacting this new member on the phone after the meeting gives the historical context of that issue? Is that a violation of the right to know law? No, that's a non-quorum of the membership of the planning board where you have one member who has longer history and knowledge of some of the issues in town trying to better inform a new member. That's not a violation of the right to know law. And then another one, I'm going to probably stop here. Is it a violation for the select board chair to query the board? Oh, no, we already did that one. Is it okay for a town administrator to decide what communications the select board receives? Boy, that's a loaded question. I think if you have concerns about select board members getting information that's supposed to be shared by the town administrator, you need to have a meeting with the town administrator and the other select board members to come to an understanding of the information select board members should be expected to receive and how that relationship is going to work. That's probably where that should be addressed. So let me continue on. I had mentioned what obviously is a meeting, but I have to take a moment to point out the statute also addresses what's not a meeting. And I've always mentioned that there's something called a non-meeting. So there are very specific provisions in the right to know law statute that says there are things that take place as membership, even a quorum of a public body, which are not subject to the right to know law. And we just used the not very specific but important term, a non-meeting. So when you have a social or other encounter where no decisions are made, if I'm having an annual Christmas party as a member of the planning board at the chair of the planning board's home every Christmas, and we're not conducting planning board business, that's a social encounter not meant for conducting public business. It's not a meeting. I could have that kind of occasion to get together with my fellow board members. Collective bargaining contacts, that is activities of a collective bargaining nature, are not subject to the right to know law. So there's two parts to that. If the governing body, along with the town administrator, have a meeting for the purpose of discussing their upcoming strategy on how they're going to conduct negotiations with the local union, let's say it's the firemen's union, that is a non-meeting. They can conduct that, not even subject to the right to know law, and develop their negotiating strategy. And then when the select board, let's say the select board assigns the chair of the select board and the town administrator to have the negotiating meeting with the union representative, that's also a non-meeting, and it's not subject to the right to know law. Consultation with legal counsel, who has to be in the room or having a contemporaneous communication with you, is also considered a non-meeting. That's not subject to the right to know law. So whenever you meet with town council, and for instance, the select board, and I've received this question recently, interestingly, could the select board not even post a meeting and go to town council's office and have a discussion on a particular legal topic? Absolutely, they can do that. And it's not a meeting. So if it's a non-meeting, you don't have to notice the public, but the public can tend to keep minutes. So anytime you consult with legal counsel. Circulation of draft documents is also kind of a narrow opportunity to have a public body draft up a document, or at least agree to the content of a letter. Let's say the select board wants to send a letter to the governor on a particular topic, and at the select board meeting, they all decide, well, this is what we want the letter to say, and we're going to assign the job of writing the letter to the chair. And the chair says, that's fine, I got the notes of what you told me, I'll write up the letter. And then the select board chair can distribute the letter to his or her fellow select board members and confirm that the letter's okay. They can confirm it's okay, and she can send it out. That's considered the appropriate method of circulating a draft document whose content was agreed to at a public meeting. However, if the members said, we don't like the letter, we're going to do it all over again, they have to reconvene in a public meeting and redraft it. And so just to remind you that this is different than a non-public session. It is just considered an occasion of meeting outside a public meeting requirement under the statute. So a follow-up question or related to this, will two members of a three-member body of the town socialize by going to a ball game with other mutual friends in town and not violate the right to know law? Yes. Do minutes need to be taken out of non-meeting? No, it's not a meeting. So the obligation to hold an occasion when a non-meeting is taking place, it's not a meeting. So only when you have a meeting are you required to notify the public, that the public attend and keep minutes. But a non-meeting doesn't come under those requirements of the statute, so you don't have to keep minutes of a non-meeting. And by the way, probably not a good idea, especially when you're meeting with town council, to have notes of those meetings, because then they might become public records, and someone might argue that they're subject to disclosure, especially if it ends up being argued that you breached the attorney-client privilege, and the content of the advice town council gave to you is now subject to disclosure, which is generally not a good idea. I think I've covered all those other ones, Ashley, the planning board member and the
I wasn't sure.
Yeah.
Sorry about that.
and those are done.
Okay.
And we'll
Perfect.
just have Mr. Doggett's question, I think we'll pick up later on.
We have any person questions?
Okay, yeah, go ahead.
So is it safe to say that if no business is being conducted, then it's considered a non-meeting? Specifically, I'm thinking about our Conservation Commission. Sometimes they'll discuss going to a site, a conservation area to clean up on a weekend and say, oh, we're gonna go clean up whatever park or whatever conservation area on Saturday. Whoever wants to show up, show up. They're just going to clean up, although they discussed it at a meeting. Is that still considered a non-meeting?
That's a really good question. So I would analogize it, first of all, to certainly land use boards. By the way, the Conservation Commission is not a land use board, but the kind of like a land use board.
Right, like an advisory.
Yeah. So if a planning board or a ZBA conducts a site visit
Mhm.
related to an application, clearly that's a public meeting.
Yeah.
This is a little bit different, and I would characterize this also as a social occasion, even though it is related to the business of the public body. So arguably, you could say it's for the purpose of doing some of its business. It's not an occasion where the Conservation Commission is going to discuss its business or make decisions. So I think it's safe to say this would be more like a social or other encounter, not convene for the purpose of conducting public business. Although I would have to confess, I could certainly see somebody arguing, well, but they are doing public business. They're cleaning up this conservation area. They're improving this trail. I would just be hard pressed to say that it is a convening of a public body, but I suppose, and therefore the public meeting requirements of the statute attach. If you wanted to eliminate all doubt, you could just treat it like a site visit. So I've been on a planning board for a number of years. I'm currently on our ZBA. We conduct site visits for every application. It's relatively simple. Someone has to be there to take the notes. Typically, you keep a record of who's there, and then you just note what takes place. And that would probably comply. We just, although you would have to notify the public.
Right.
The Conservation Commission is going to be conducting this public activity at this location at this date and time. Those who wish to assist and attend are welcome to attend. And then somebody has to be assigned the job from the Conservation Commission to keep attendance and keep minutes. And I think that would comply.
And a follow-up question of notification on that. If we posted it on our website and our Facebook page, would that count as two?
No,
No.
it's got to be posted in at least one public place. Posted, and a public place means at the
So somewhere at
library.
town hall or
Yeah,
something.
town hall, what I love is we have them in our community center and in front of our town hall. It's, the standalone
Right.
thing with behind the glass, and that's where it's posted.
balloon,
That's,
yeah.
that's the better practice.
Okay.
So we have a question about abstaining and recusing. Let me just hold that for a second. So a question, very interesting follow-up question. Should the public be invited to a site visit for forest management in anticipation of harvesting by the Conservation Commission? Well, if the Conservation Commission is conducting a site visit to help supplement the information base upon which they're going to form a decision, do we conduct a forest management activity? And we have a forester there who's giving us advice. We're receiving that information. And then the Conservation Commission is going to later on convene in a meeting to discuss a timber harvesting plan. Yeah, that's probably a public meeting. You should let the public give notice to the public, let the public attend. Can the planning board hold a site visit the morning after the meeting, or does it need 24-hour notice? It needs 24-hour notice. Although, here's the tricky thing. There's this provision in the statute for the planning board. Actually, I know the answer now that I thought about it. So there's a provision in the right to know in the planning board statute. It's RSA. I just looked it up this morning, so I happen to know where it is. 676:1, Roman 1, small letter D, 1. Okay, what that says is, if you may be familiar with planning board business, the planning board has to send notice of its public meetings to accept a plan or have a public hearing on a site plan or a subdivision plan 10 days before the meeting, and notice to abutters by first-class mail or verified mail. But if the planning board has given that notice and has conducted that public meeting, and the public were hearing, the public has attended, the planning board can continue or adjourn the meeting to another date without giving further notice under the planning board statute. But it would still have to give notice under the right to know law. So in this instance, the planning board voted, we're going to have a site visit tomorrow morning, but they don't have 24-hour notice sufficient to comply with the right to know law. So they can't hold that site visit unless they're able to promptly give 24-hour notice. So rather than the next morning, they should do it the morning after. And then they can comply with at least posting notice on the website and to the public that the public is aware that it's going to be a site visit within that time frame. Within the time frame that's specified in the notice. So as I've said, what are the requirements of a public meeting? Well, you have to have public notice. It has to be open to the public, and you have to have the meeting minutes. These are the fundamental idea behind the right to know law. The public has to know that the meeting is going to take place. The meeting has to be open to the public. The public has to be able to go to the place and attend the meeting. And that you then have to record the action of the public body, the discussions, decisions made at the public meeting. And those are the basic requirements for every public meeting under the right to know law. One of the things that I think is useful to be reminded about posting meeting notices. We'll get into some of the details about the posting. The statute was amended a couple of years ago to clarify what is the duty of a public body or a town to give notice of public meetings on its website. So I just want to go over that part of the statute because I think some communities are not quite understanding what the requirement is. Although I think whenever when I'm answering questions in the legal advisory service, about 9/10 of the time, the first thing I do is go to the community's website and go look to see, well, what's actually going on. So just so you know, if I get a question about there's some dust up between two members of the select board, the first thing I'm going to do is go look through the meeting minutes to say, well, what actually happened, and see what's the meeting minutes, or I'll go read the zoning ordinance. Well, in this instance, I guess what most of you are doing, which makes perfect sense, what the statute calls for, if you choose to post your meeting notices on your website, you have to do so in a consistent and reasonably accessible location. So most communities are doing just that. You're posting your meeting notices on your website. But I think and my town does it in a way that I don't really like, but that's okay. It's the way it goes. I think the better practice is on the landing page, and I'm going to use an old newspaper aphorism, above the fold, right? The first thing you see, right over to the right, there should be a square that says public meeting notice location. And you should list, what are the upcoming public meetings, and or have a hyperlink to where all of the meetings that are upcoming, or to a calendar, however you want to do it, so that it's, right there as the statute contemplates, in a convenient and reasonably accessible location. Now, the statute goes on to say, which is in some of the smaller towns, this is true. If you don't post notices on your website, or maybe you don't have a website, you have to post and maintain a notice on the website where meeting notices are posted. So you're not required to post meeting notices on your website, although it makes sense. If you don't, you have to post a notice saying, meeting notices for the town of Bow are all posted in these locations, at the town library or at the town hall. The other part of this that I guess I want to spend a little time going over are the posting requirements. So I've already mentioned it has to be 24 hours notice. Just remember, the posting requirement excludes Sundays and legal holidays. So if that planning board just a little while ago held their meeting on, well, let's say it was Saturday, some crazy reason they held a planning board meeting on Saturday, but they posted the meeting notice on Saturday afternoon after the conclusion of the planning board meeting, saying that the planning board is going to hold a site visit on Monday, it wouldn't comply with the statute because you have to exclude the Sunday. So we always have to keep in mind that Sundays and legal holidays come out of the 24-hour period. It has to include, that you have to exclude those dates and still get 24 hours notice in for notice of meetings. One of those, some communities actually post notices in a newspaper. The other thing, which I mentioned, which most towns are already doing, is just make sure your meeting notices are posted in a readily accessible location. Now, I don't want to pick on the town of Hudson, but I know that there had been occasions where the town of Hudson had this bulletin board down a hallway, which was not really easy to see, but I think it was significantly minimized by the fact that the town also has that big bulletin board out front with the glass. So it really has to be in a place where the public has access, and it has to be really accessible 24 hours a day. So having that bulletin board behind a glass in the front of the building is probably the better way to go, because that way people can see it and then not have to navigate a hallway to find where the notice is in the hallway someplace. The other thing, just to be reminded with regards to posting requirements, this is just the right to know law. This is the minimum requirement for a public meeting. It doesn't supplement the fact that you have an obligation in another statute to give notice in some other fashion, such as I mentioned, the planning board has to post notice, send notice by a first-class mail, verified mail, to abutters and those who have, easements and other interests, or engineers who seal on a plan that's being considered. These people also were entitled to receive notice by verified mail or first-class mail. Verified mail is now the requirement. That's been eliminated in terms of first-class mail and requiring it by certified mail return receipt requested. I'm going to talk about emergency.
Oh, we have an in-person question?
Yeah, go ahead. Yeah.
Sorry. So I think I heard you say earlier that we don't necessarily have to post the agenda, although it's a good idea, we do. That we just have to notice the meeting. We have a resident that is consistently complaining that we don't give enough detail about a specific project that is going to the board. We feel like we give, paragraph, where the property is located, a basic idea of what it is. But he consistently is on us about not giving enough detail. Are we in the right? I believe we are, but.
So certainly the right to know law doesn't require that you provide backup detail on action items that are going to take place at a select board meeting or other public body. The idea of providing access to the packet that is going to be employed by that public bodies, planning boards, governing body to make decisions and make it available online, that's not a bad idea.
We have recently started doing that as well. Yep. On our
Well, there you
website,
go.
yep.
So that takes care of the issue, it seems to me. If someone wants that detail, they can go access the packet and they can download it and look at it,
Right.
just like any board member can. And
Right.
that eliminates that concern, it seems to me.
Yeah, we consistently explain that, we keep it brief, just to let you know what's going on, and you're welcome to explore it more.
Right. We have a question here. What's the difference between abstaining and recusing? Do both affect the quorum? That's a really interesting question. There's actually a number of cases on that in New Hampshire. So someone who abstains is refusing to do their job as a member of a public body. Now, I think a lot of people think, well, if I wasn't at a meeting, how can I approve the minutes that I wasn't at? And actually, you should know that Robert's Rules of Order makes it clear that even though you didn't attend a meeting, you can still vote to approve the minutes. You don't have to abstain. But as a member of a public body, if you are appointed or elected, it is your obligation to attend meetings and to make decisions. And if you're abstaining all the time, you're not doing your job. And certainly planning board members can be removed from office for not attending to the business of being a member of a public body. So I don't think it's prudent for public body members to abstain. Recusing is different. You have to recuse yourself because you have a conflict of interest. If I'm on the ZBA and my brother-in-law, who I don't really like anyway, but he's my brother-in-law, and he's the applicant for the variance, I've got to recuse myself, or if I'm in a butter. So that's just, there are requirements in certain circumstances you have to recuse yourself, but that's different. That's not the same thing as abstaining. Abstaining, as far as I'm concerned, it is very rare that a member of a public body should abstain because you're elected or appointed to do public business, and abstaining means I don't want to do anything on this front. And you have to ask the question, well, why not? That's why you're here. So in any case, that's the difference. Question here is that if the chair of a select board is asking for members, let's assume it's a select board, for items on the agenda, okay, under RTK, what about the chair asking that all proposed corrections to the minutes be sent to her ahead of the meeting? Well, it's just two parts of that question. Number one, I think it's the better practice for public bodies to have rules of procedure. And it's a good idea to really focus on one person of that public body whose job it is, and maybe consultation with staff to put the agenda together. But asking members to submit items for consideration, and they would be sent that request for suggested agenda items by email, preferably by town staff, it could be by the chair. The chair sends it using the blind CC method. And the member is encouraged to send suggestions for agenda items back to the chair. But with the understanding, the rules of procedure have already said it's ultimately the chair's responsibility to put the agenda together. So you're not having a decision-making process, you're just having a consultative process where the members are suggesting items. That's okay. The last part of the question, I'm sorry, I can't remember. What was the last part of that question, Ashley?
So it was about the the chair asking for agenda items ahead of time?
Yeah, I think I covered, there was another
So
piece.
minutes and agenda items.
Yeah, and so, yeah, right, asking for, so I think the better practice with regards to minutes, this is what we do on my ZPA. I think the better practice for getting input from members on minutes for meetings that they attended, obviously, is just, again, the chair could send it out by the blind CC method, or staff could send it out. But members should come to the public meeting and then suggest corrections that they think are necessary. I don't think it really should fall to the chair to then compose or recompose the minutes and bring them to the meeting for approval. That should be done at the meeting. So send us, here's the minutes. What do you think? Bring your suggestions for any amendments or changes to the minutes to the public body meeting the next occasion you're going to meet. That's the better practice. Yes, go ahead.
So just a quick thing on the notice. You said the notice, public notice should be accessible 24/7. Is that a recommendation or is that a requirement? Public notice being.
Well, posted notice. Yeah, posted notice. I think
I get.
it should be in an accessible location. So it doesn't have to be 24/7. So for instance, we post notices in my town at the library, and we have a little vestibule that is kind of accessible 24 hours a day because there's mailboxes there, where people can walk in and get the mail, and there's a bulletin board. It is accessible. It's not in an inaccessible location. Preferably, I really think the better practice is to have that bulletin board out front of the public, the town hall, the library, that's in a glass encased, it's locked, and that's where public notices go. If you can do that, I just would encourage that approach. What I am saying is, don't post it in a hallway that is kind of obscure and hard to find. That's not a good idea. Yes.
If your website has like Google Calendar and you keep that updated with the meetings, times, and locations, is that considered to be a notice?
That would be considered a notice on the website.
Right.
You're still going to have the paper notice posted someplace else.
Right.
Yes.
So we do 2 locations and then we have the Google Calendar.
And that's fine, yeah. And the Google Calendar, I mean, I'm not sure how that functions, but it's like an adjunct to your website. Is it like people go into it from your website?
Yeah.
As long as it's connected easily and people get to it, then yes, that would be fine. And just, have the link for the Google Calendar on the landing page so people can see it immediately and go directly to it.
Yes, we have a toolbar and that's one of the categories. You click on it, it's called calendar, and then it's all boards.
Yeah. That's good. Okay, so how are we doing on people attending here, Ashley? Everyone is still with us? Okay. And I see you have some chat, but that's not for me. Okay.
Me and Jonathan.
So let me just turn to the issues of remote meetings or virtual meetings. So you all may recall that, we had a bit of difficulty running public body.
What is that? Oh, did
I moved my thing here,
oh,
sorry.
so you.
Yeah, I
Okay.
accidentally, so the technology is very sensitive. I can't make any wrong moves. Okay, sorry about that.
It's a relevant slide for that.
Yeah, it's very relevant, yeah, perfect. So during that wonderful time called the pandemic, which by the way, I'm sure you all saw that Dr. Fauci said that we're out of the pandemic. I think that's what he said. I hope that's what he said, but
That's what he said.
then maybe, fingers crossed, you don't want to make the gods of the pandemic kind of turn around and come after you again. But in any case, so we had this emergency order number 12 that allowed remote meetings of public bodies, which was great and it worked, but it ended in June of 2021. We don't have that anymore. It's gone away. So since that state of emergency expired, you always have to have the physical location of public body meetings, and you have to have a quorum at that physical location. But nothing prohibits public bodies from allowing the public to participate remotely if you want to do that, and to allow them to participate remotely. So the number of variables there, you can let people watch on Zoom, but are you going to allow them to speak on Zoom, or to have, that would have to be a Zoom meeting, I think, as opposed to Zoom webinar, or can they post questions on Zoom? Can they participate in public hearings? I think these are all things that you have to work out locally and what you're going to allow people to do. I think, I suppose, if it's a local resident issue and you'd be concerned that you have non-residents participating, well, people who are non-residents of your community have a right to participate, to listen, attend public meetings. I think they could also attend and participate in public hearings. So you have to develop some internal policies, how that's going to work. You know, are you going to make people identify who they are? Are you going to let people attend anonymously? These are all variables I think you have to work out, but I don't know that there's any specific requirements you have to follow. I just would encourage that to the extent you allow remote participation, it's not a bad thing to continue. On my ZBA, we still have members of our ZBA, because we have to have a quorum in the meeting, but we have one member who, you know, is concerned about, you know, being, you know, compromised, both himself and his wife. He participates remotely, but we also allow people to participate remotely, even applicants and those who can't attend the meeting. And there's a lot of flexibility in that. I mean, I can certainly understand. I've certainly seen it in certain land use applications where they might be using an engineer from Massachusetts or New York or even California. And are you going to let that person participate in your meeting remotely? Well, why not? I mean, that could be making a degree of flexibility and working with applicants to the benefit of the community. So I don't have any specific rules that suggest how do you manage remote participation. The idea of requiring people identifying themselves, not allowing an anonymous participation, that's reasonable. Not allowing or allowing people to speak remotely, I think that's within your realm of allowing what you want to occur. These are just kind of local choices you have to think about, but that just want to emphasize you still have the ability to allow remote participation if you wish.
But so just to clarify, that's if you wish to allow remote, you
Yes.
don't have to.
You don't have to.
Okay.
Okay, so we have a question here. Can a planning board decide not to allow a member to participate remotely, assuming a quorum is present at the physical location to vote on any issue because they believe it's unfair to the applicant not to be present physically? Well,
That's Steve, and the same person just wrote a follow-up.
in the case I'm citing, the member was replaced by an alternate who was present. Well, let's talk about remote participation because that ties into this question. So just to go through the requirements, and again, we have a checklist in our right to know book. A member, public body may allow, you're not required to, a member not to be in personal attendance because their personal attendance is not practical. There is a quorum at the physical location. All the board members could hear the member participating remotely. The member has to identify anyone with them in the remote location, and all votes must be by roll call vote. But we don't have, and this ties into the question from Beverly, we don't have a specification in the statute or any cases on it that tells us what does not reasonably practical mean. That is, their personal attendance is not practical under the circumstances. It has been my advice that it has to be due to some unexpected set of circumstances that the person cannot be present, or circumstances which dictate their presence might be harmful to their personal health or well-being. That's how I approach the issue. Now, I don't have any cases or decisions that support that, but that's how I think would be a way to reasonably interpret not reasonably practical. So when a board makes the decision to let that member participate remotely, that's a decision to be made by the board. And I think they should be guided by those principles, that the person is in California taking care of a sick relatives and they can't be at the meeting. And that seems their attendance is not reasonably practical. As compared to, well, they really wanted to go to the Celtics game, and so they're going to participate from the parking lot. Oh, wait a minute, you know, that's okay. That's not what the statute contemplates. So, you know, I would just say to Beverly, the member wanted to participate remotely. I think if they had a basis to say that they can't really be there for a legitimate reason, like the member on my ZBA right now was participating in all matters remotely because of his status in immunocompromised, we always agree and let him do it. So I think it has to be a board decision. I think those would be the principles you'd be guided by. And I see that in that particular instance, the member was replaced by an alternate. Okay, but I'm not sure it's reasonable to say it's unfair to the applicant that the member to be present physically, because I did enough of these remote meetings, and I have to say, being able to have the applicant's engineer bring the plan up on the screen, I'm at home, and then the applicant's engineer can zoom into the plan and say, this is this is that. I can't say, I have to say, some of the best presentations I saw was on a remote presentation by an engineer who was able to zoom in and out of a plan and really accurately describe what was going on. So I just really don't feel that really is prejudicing an applicant in those particular settings. So I guess I wouldn't necessarily agree with what was done in that particular situation. Then we have a question from Ryan. If a board is acting on an application and there are members present for a quorum, some being alternates, but there are full members via Zoom or other, is there a requirement for any voting acting to be acted on by the quorum physically present, or can the full members by Zoom act? Well, I guess the answer would be this. In order to have the quorum in the physical location, you had to appoint alternates. Then there's going to be some bumping of the members who want to participate remotely, who are regular members. So let me just answer the question this way. So what my chair does when the chair is making the decision who's going to be voting on a particular case, he first looks around the room and says, okay, I see we've got 2 regular members here and 2 alternates. I've got to have a quorum here, so I'm going to appoint Steve to sit for Jim, who's participating remotely, and I'm going to appoint Paul to participate as an alternate for Carol, who's participating remotely. So they've been replaced. They no longer are sitting as planning board members for that particular case because their position had to be supplemented by the appointment of an alternate because of the need to have that quorum in the physical location. So I think in that instance, those 2 who are remotely have been replaced. They're not allowed to vote on that particular case. Now, you might have one other member who's allowed who was not replaced. And the decision to make judgments on who is going to sit as an alternate, that's done by the chair. That's the chair's responsibility. Maybe the chair is being selective in who they're going to replace. Okay, I can understand that might be a little politics going on there, but that's really the chair's responsibility. Now, if the chair was doing that repeatedly in a fashion that was really denying someone who couldn't participate in a physical location, doing that intentionally, that could be a separate issue. But this is a one-time thing, and I don't think that's an issue. Yes?
That's very confusing. Does that mean the chair needs to sort of delineate as they're appointing alternates who they're replacing during
Yes.
that meeting
I
at
think-
the very beginning?
At the beginning of the meeting, I think they need to make that clear because that's going to be necessary to decide who's then allowed to vote remotely. So yes, there's a little bit of that has to take place. One more question. What about someone who travels a lot for business? Should that person be allowed to continue to present via Zoom? Would the best practice be for that member to resign based on his or her unavailability on a regular basis? I think that's a policy decision that may have to be made by the member in consultation with the appointing authority, which is usually the governing body. And maybe that would come up at the time that person is going to be reappointed. The other thing I would say, just my own personal point of view, maybe everyone doesn't agree with this, but those who are snowbirds, who are on the ZBA, who are down in Florida from November until April, I don't think they can argue their attendance is not reasonably practical. That was a personal choice, and maybe they really shouldn't be on a board where they're supposed to attend on a regular or monthly basis. That would just be my point of view. Yes.
So that's kind of what I was gonna ask. So we've had select board members that are snowbirds and have used the emergency meeting for periods of time through January through election season, town election season, which has been contentious for the public because they don't understand why there's an emergency meeting, but business has to take place to some extent. So there's nothing that really says, it's extenuating circumstances, but they'll say it's for non-public that has to take place, or somebody needs to be appointed for something. No other business other than those specific things can take place during those board meetings, except for the things that need to be addressed immediately, correct? Or can it be a regular meeting, an
Well-
emergency meeting?
Well, let's talk about emergency for a second here. So the chair can declare an emergency that exists in order to satisfy the requirements of the statute. And you still require a physical location of the meeting, but in those rare circumstances, you don't need a quorum of the public body in that location. Now, I would tell you that in consultation with a lot of other attorneys who advise municipalities, there is going to be very rarely a circumstance which will justify an emergency. And so, if it is due to the unavailability of a board member who absents themselves from the community for 3 to 4 to 5 or 6 months at a time, I'm questioning whether that's appropriate under those circumstances. And by the way, I think the emergency requirement, which I'll go on here for a second, emergency means a situation where immediate undelayed action is deemed imperative. And it is the presiding officer has to post a notice and make a decision. We got to do something. We got to do it now. It has to be done. And we can't give notice, and we can't get the rest of the board together to make this decision. So the example that I've always given in the past is if you got a community that's bisected by a river, and the only bridge across that river has just been blown down by a flood, and you've got 2 select board members on one side of the river and 1 select board member on another side of the river, and it's a 3-member select board, and they have to have a meeting immediately dealing with the emergency issues that have cropped up, and they've got to take immediate action. And there's just simply no way they can get a quorum of the select board. By the way, the town hall is on the other side of town with the 1 member of the select board, the other 2 are over here. So you can't get them there, it's impossible. So you have to have an immediate emergency meeting because undelayed action is imperative. Let's say there's some, the only way we can accept assistance of an emergency nature from FEMA is to have some kind of vote by the select board. You could do that under those circumstances and say that you would give notice with less than 24-hour notice and have the physical location of the meeting, which is a town hall with the one member of the select board and the other 2 participating remotely. And you could do that, but that is so rare. And the requirement that you show immediate undelayed action as being imperative is going to be an unusual circumstance. And I just can't see how a member who's regularly in Florida for 6 months out of the year, and there's a need to have 1 member, let's say for some other reason, your 3-member select board, you got 1 member who's just unavailable for other reasons, and you've got the member in Florida and the member in town. I just don't see that that's going to comply with the requirements of emergency to hold a meeting and make decisions in that manner. So I just don't think it's a good idea.
So who speaks up? If you have a town administrator, do they have to say, no, we can't have an emergency meeting because the chair is the one who's holding it?
Well, ultimately,
Or do you just do it and then see what the public does?
well, it's the chair who's making that declaration.
The chair is the one who's out of state.
The chair has to make this an emergency. I'm sorry, what did you say?
The chair is the one who's out of state.
Okay, well, yeah, I mean, that's encumbered with all kinds of personal interest in making that decision in those particular circumstances. So, I think the worst case scenario for a town that is in that setting is that whatever action that is taken at that public meeting can be thrown aside, because one of the powers which Jonathan will cover in a bit, a Superior Court has the power to avoid any action taken by a public body at an illegal public meeting, and that's likely what could occur. So if there's a vital decision that is made, it could be thrown out and on appeal. So it's not the town administrator's job to veto the meeting taking place. It is the chair's responsibility to make that declaration and to call the meeting with less than 24-hour notice and with less than a quorum. But she could really have a good reason. And I think the flood in the town bisected by a river and only 1 bridge across the river, that's really the only one that I know of that I've contemplated. The other one, which I did think about, I suppose, there could be maybe, a reemergence of the pandemic and the mandate, and maybe the governor has not acted on a new emergency order, which you probably have a hard time doing given some changes in the emergency powers given to the governor. But if there's no emergency order, like emergency order number 12, but there was a need for an immediate meeting and there was, a mandate to remain at home, I suppose that might be a sufficient emergency circumstance that will allow a chair to have an emergency meeting under those circumstances. But otherwise, I think anytime that you don't fully comply with the statute and really do have a situation where immediate undelayed action is imperative, you risk any action taken at that public meeting as being declared void or voidable. So tread very carefully if you're a governing body member making that decision.
Steve, you have 30 minutes and 12 slides left.
Okay. So meetings open to the public. I just wanted to take a little time going through meetings open to the public and kind of some of the things that that relates to. So as I probably said before, and we've received this question a lot recently, those who attend your public meetings can include non-residents and residents. So when the meeting is open, anyone can attend those meetings. You can even have non-citizens, although technically, I suppose, non-citizens may not have the same status in terms of the ability to speak. They still are members of the public and probably are entitled to speak at public meetings if they wish to, and if they've been invited because you've called a public meeting to have a public hearing. And at the public hearing, presumably that's what you're looking for, members of the public to speak. So keep that in mind. It's not just those who are local taxpayers who can speak. I guess we've also received the question recently, can non-residents speak at public hearings? And I would just emphasize there's only one case I'm aware of where non-residents were prohibited from speaking at a public meeting, and it was a New England town meeting. Now, in a New England town meeting, the people who are attending that meeting are acting as legislators. In order to act as a legislator at a town meeting, you have to be a registered voter and you have to be signed in by the ballot clerks. But the person who was not a resident of that particular town, who was in Massachusetts, wanted to speak, sued under the First Amendment, and the First Circuit Court of Appeals made very clear, no, that obligation to let non-residents speak does not apply, but that's where the registered voters are acting in their legislative capacity. Only legislators can speak at a town meeting, and those who are not residents cannot speak. Now, one of the things that the statute also says, it's open to the public, and the statute makes clear that that means that those who attend can take notes, tape record, take photos, videotape, do any manner of recording what takes place at that public meeting. And they don't need permission. So if they come into the meeting and they sit down and start recording, they don't need to have the permission of anyone in that room to record their voice. And we had a really interesting question, which I'm going to answer later on, the legal advisory service. Can someone come into a public meeting and before the meeting is gavelled open by the chair, can they start recording? Well, the meeting hasn't started, so why are they allowed to record? Well, the answer is that you have a right to attend public meetings, and the public meeting technically has commenced once the quorum of the public body is present. It doesn't have to be opened. So the member of the public who starts the recording before the meeting starts, technically, that's still a public meeting, and they can start recording as soon as a quorum is present for the purpose of acting on matters within the jurisdiction of that public body. The other aspect of yes, go ahead.
It's kind of an assumed public forum as well.
Yes.
So kind of locking in with that concept.
Yes, it is a public forum, and there's a whole bunch of analytical tools we use as lawyers in deciding what are the duties of government under the First Amendment to allow people to participate and share information and freedom of speech. But yes, it's actually considered what under the law a limited public forum. There's also the other aspect of the statute, which is important to keep in mind in terms of not only being able to record, but also know what's going on. So there's no secret balloting at a public meeting. You can't have a secret ballot in any way whatsoever. The only time you can do a secret ballot at a public meeting is at a town meeting, and because there's a statute that says you can call for a secret ballot, but you can't have a secret ballot at a select board meeting, planning board meetings, any other meeting of a public body. You're not necessarily required to allow public comment, but it is something that public bodies have to address. And it's a good idea to think about beforehand. Are you going to have a public comment section for your public meetings? Clearly, when you're having a public hearing, you've asked the public to come speak. But are you going to have a public comment section? Many towns do have public comment. So they'll allow people to speak to them at some point in the agenda, preferably items on the agenda, and within certain parameters. And those parameters are your public meeting comment rules. So some of the things that you should think about and having in your public comment rules would be, first of all, unless you give someone the right to speak, they're not entitled to speak at your public meetings. Only when you've asked them to speak at a public hearing, they have a right to speak. You don't have a public comment period in your public meeting, and you're not required to have one. You could have one. Better to have these rules. A couple of things that I think are probably key to keep in mind when you are managing public comment at public meetings. Number one, lay out the rules for everyone to see, preferably in writing, so that these are part of your meeting rules procedure. Number two, understand that the First Amendment will allow you to control the time, place, and manner of public comment. And by time, the better approach is to, in your public meeting rules for public comment, say, those who wish to speak, number one, have to sign up. There's a sign-up sheet. Number two, they will speak in the order in which they were signing up. Number three, they will speak for, insert the number, 3 or 5 minutes, no longer than 5 minutes. I think 3 is preferable. Number four, that their comment should be on something on the agenda. Number five, if they want to speak on something not on the agenda, you have to let us know beforehand, and we'll arrange for a time for you to speak to the public body on that particular subject. Once you've spoken, you don't get to speak twice until everyone else has spoken. And finally, one thing you can prohibit very clearly is repetitive comments. So if someone is saying the same thing over and over again, repetitive comments have the potential, the capacity of impeding the business of the public body, because if people keep saying the same thing over and over again, pretty soon all you're listening to is the same public comment rather than the rest of the public business of that public body. So you can ban public comments. What you can't do is say only positive comments. Can't do that. You can't prohibit members of the public wanting to speak to, a complaint about a public official. That's just not appropriate. You can probably tell people don't swear or use obscenity, but unfortunately, as we've all seen nowadays, that a lot of obscenity is considered protected speech. So you probably admonish someone not to use that four-letter word, but if that's how they got their point across, they're probably going to get away with it. Clearly, they can't yell fire in a crowded room, but using inappropriate language is necessarily something where you could stop them from speaking because it's probably protected under the First Amendment. You certainly can't prevent a particular person from speaking. That's why I don't think it's a good idea to say only residents can speak to the public body. And you certainly can't prevent the wearing of certain attire. So if I wear a t-shirt that say, I think the select board are liars, I can do that, and that's permitted, and that's protected speech. Ultimately, it comes down to controlling the manner of that public meeting. So if someone is being disruptive, not following the rules, after they've been warned once, twice, probably 3 times, their time is up, they're not abiding by the comments on issues on the agenda, whatever the case may be, the ultimate power of a public body chair is to have that person arrested for disturbing the peace. And there's actually a Supreme Court case on that where a select board member was ordered to be arrested by the chair of the select board because that select board member was continually interrupting the process of the meeting and was not abiding by the rule that you had to speak to the chair and you had to be recognized. And after that had gone on for long enough, he got arrested and he challenged his arrest, and the Supreme Court said, no, that's perfectly permissible. But it's the last resort. I don't encourage it. I have a question here. The planning board room setup allows only the members of the planning board to see the exhibits used by the presenters and not the public participating in person. Doesn't this violate the spirit of the open meeting? I think you need to arrange the room so that all of the information the board is making, that will be using to make a decision, is available for not just the planning board, but also for the members of the public. So I would agree that the meeting room arrangement should be set up so that, you know, you've got the presenter at a podium like this, the planning board is over here in that corner, and the audience is over there in that corner. So there's, you know, a multi-dimensional display of those who are participating as members, those who are participating as those who are applicants, or those who are attending the public meeting, and then the speaker, so we can all see and hear the entire presentation. And ideally, maybe, especially if it's being, I know that we do this from IZBA, we still have everything broadcast. So we have the big speaker, the big TV in the room, and we can see those who are participating remotely, and then we broadcast and project the plans that people are talking about. So everyone in the room can see it and those at home can see it. That's certainly the better practice. And then just a mention here on note here, the amendment, First Amendment allows you to record in any public setting. Yes, I think that's generally true. So just understand, and Jonathan certainly can answer questions like this on this, I suppose, that we have a wiretap statute. And so the wiretap statute says you cannot record someone speaking in circumstances where they have an expectation of privacy. So most people have no expectation of privacy if they're in a public place. So they could be recorded in a public place, both video and audio recording. But so yes, I think generally it's true. If you're in a public setting, you don't have an expectation of privacy, and the wiretap statute doesn't apply. So your image and your voice could be recorded. Just a few more things about public comment. I've already mentioned you should have rules. You can regulate the time, place, and manner of the speech at a public comment. You can limit the time for comments, and you cannot require only positive comments. And then I've already mentioned state versus dominant. You do have to have public meeting minutes. I will get through this, Jonathan, I swear. So you do have to have public meeting minutes, and there's a minimum requirement. It's not that extensive. So understand, the right to know law does not require a transcript of meeting minutes as a required representation of what took place at that meeting. You have to have the names of the members present, the persons appearing for the public body. The persons appearing does not mean anyone in the audience. It has to be someone who spoke. So, and by the way, so if you're a chair of a public body, if someone comes up to speak, really good idea to make sure the person states their full name and preferably their address so that it can get recorded in the minutes. You have to have a brief description of the subject matter, to state any final decisions made, state the names of the members who made or seconded any motion has to be recorded. So the motioner and the seconder has to appear in the minutes. That's the minimum requirement. Now, for land use boards, and I used to represent the town of Hudson, that's why I was picking on the town of Hudson. Paul Intervitson is here as the moderator. We had a person who did the minutes, Brad Seabury, and they were impressive. They went on for pages and pages, and I love those meeting minutes because they were so thorough. And as town council, I wanted to have the kitchen sink in the minutes in order to defend the decisions of the land use board. You don't have to have that, but this is the minimum requirement. You do have to make them available within 5 business days, which means in most instances, you're going to make the draft minutes available because you're not going to reconvene the public body to approve the minutes in 5 business days. So you have to have some system where you have confidence in the persons taking the minutes to compose something that reasonably represents what took place, make those available in 5 business days, and then you would have them corrected and made available as a corrected version later on when the public body reconvenes. I know a lot of public bodies are recording meetings through Zoom, like we're recording here, or using other technology. And I would just say a recording is not a substitute for minutes. So you can't post the Zoom recording of your public body meeting and say that that complies with the right to know law. You still have to have minutes.
It's a minute related question.
Can a board correct minutes of a non-meeting? And if so, what is the process? Well, you wouldn't keep minutes of a non-meeting, but if you had a non-public session, you can You can now have a non-public session to discuss releasing minutes that you've composed that you've voted to keep non-public. Let me just hold that question for a second and I'll come back to that when I get into non-public sessions, which is right now. So we've covered non-public meetings. I mean, we've covered public meetings and non-meetings. Now we're going to talk about non-public sessions. And what I always feel is important is to say these four things. Number one, it's a non-public session, not a non-public meeting. That is, a non-public session always takes place within a noticed public meeting. There's no other way to do it. You have to have a noticed public meeting and then you convene in a non-public session. A non-public session is different, obviously, from a non-meeting. A non-meeting is something that's not subject to the right to know law. A non-public session is the exception, not the rule. You are allowed under rare circumstances, dictated by 91-A:3, to convene a non-public session. And non-public sessions are permitted, but they're not required. And there have been many occasions in the past where the legal advisory service were asked, a member of the public says they have to have a non-public session. And are we required to grant their request? And the answer is no. You can make a decision to go in a non-public session when it's appropriate and when permitted under the statute. And what are the common reasons you go in the non-public session? Well, you go in the non-public session to discuss the discipline or compensation or investigation of charges against a specific public employee who's on staff in your particular community. You can go in the non-public session to discuss the hiring of a person as a public employee. You go in the non-public session because the discussion would impair the reputation of a person who's not a member of the public body, and you want to protect their reputation. You can go in the non-public session to discuss the acquisition of real or personal property. If because having that discussion in public would adversely affect the community, you're going to have a discussion as to whether or not to offer the person $50,000 when you really have $100,000 to offer, but you want to hold a little bit back because you want to save the community some money. You can have that kind of discussion in non-public session. You can have a discussion about pending litigation brought by the community or against the community. You can discuss, in certain circumstances, emergency preparation, which is a very narrow topic. It's preparation for circumstances to thwart the adverse circumstances of a terrorist attack on your community. So it's a pretty narrow emergency preparation requirement. You can also discuss legal advice. So if the town attorney, if she sends you a legal communication of advice, you can discuss that in non-public now. Rather than having to have town council present in the room, you can get an email communication, or the board chair can speak to town council. She gives the board chair advice on a particular issue, and the board chair can vote to go in the non-public session, and they can consider that advice in a non-public setting without revealing the nature of the communication and to protect the attorney-client privilege. And then you can now discuss whether to disclose previously sealed non-public minutes, which doesn't necessarily apply to the question I had a little while ago. There was a question about going to non-public to discuss whether to seal minutes. Let me get to the sealing of non-public meeting minutes, but I just want to cover here. These are the most common reasons why municipalities would typically convene a non-public session. These are the ones which are the most often occurring in the communities that we advise.
Can we just clarify one thing?
Sure.
I was looking back at the non-meeting and it says consultation with legal counsel, and this one says discuss legal advice. Would the non-meeting be actual legal counsel in attendance versus the non-public session be maybe the chair relaying information that was given by the legal counsel?
So the non-meeting has to have a contemporaneous exchange between the lawyer and the client. So in order to have a non-meeting, the lawyer has to be on the
present,
telephone
right.
or in the room.
Right, okay.
Yeah.
So this one though could be like discussing a previous conversation with the lawyer, but the
Right.
lawyer's not necessarily present.
Correct.
Okay.
Or it could be, I got an email from the lawyer telling us how to handle this application. Let's
Perfect.
go over that advice.
Thank you.
That you could do that. There was a question about minutes, and Beverly asked a very good question. Municipalities can post meeting minutes online. And if you choose to post meeting minutes online, you're only required to post approved minutes. You're not required to post draft minutes. So if you don't want to post draft minutes, that's okay. You're only required to post approved minutes. And then another question here, if a public meeting is recorded using Zoom, is the town required to keep the recording? Well, good question, because this ties into the retention of public record statute. The retention of public record statute actually says if you use a tape recording, and that could be a Zoom recording, that is used by the minute taker to then use as a resource to prepare the minutes, that recording, whether it's audio recording or Zoom recording, can be discarded if you wish, once the minutes for that meeting are approved. So the answer is no, you're not required to keep the Zoom recordings, but again, that's a local decision. I'm going to skip the next question about recording in an accessible area. Well, let me just quickly try to address this. If you are recording from an area accessible to the public, then there's no expectation of privacy. True. So if you are attending a public meeting, you are inside the public meeting area. Any conversation board members are having prior to the meeting starting are not private, and they should not expect privacy in that location. Agreed. So if there's a quorum of the public body present, now my right to record has been triggered. And if they're having a conversation before the meeting starts, I'm allowed to record that because I'm at a meeting, even though technically the meeting has not started. So to enter non-public session, have a motion to enter the non-public session. It has to be made and seconded. Motion has to state on its face the exemption that's relied upon. And there must be a roll call vote, and a simple majority is sufficient. You have to keep minutes of a non-public session, and the minutes have to, as the statute now requires, record all actions in such a manner that the vote of each member is ascertained and recorded. So I would just encourage you to use our non-public session checklist, which has a section in it for all of these elements, including a section for how you would include the recording of what took place in the non-public session. But this key element is if there are decisions, and you can make decisions in non-public session. When you make decisions in non-public session, clearly you have to record, as the statute now says, the actions of each member so that the vote of each member is ascertained and recorded. So when you conduct a non-public session, keep in mind you can make decisions, and that there's this new provision that a member could say, I don't think we should be in non-public session. I object to this non-public session. It's not appropriate. And I want it recorded in the minutes that I objected to this non-public session, but I'm going to stay and make sure no bad things happen. And so the statute allows that person to make that statement that has to be recorded in the minutes. And then that person is immunized from any penalty that could be visited by a Superior Court judge because he did something really bad. The statute does contemplate, as John will point out, that one of the remedial actions a court can take is specifically fine public body members for violating the right to know law. But you would be immune from that because you said, I think this is wrong. We shouldn't do this. And I want to record it. Yes.
So are you immune from that, even if you say that, but then you participate in a conversation and you offer your opinions and participate?
As long as you made that statement and it's recorded, and it has to be recorded in the minutes, you are able to avoid the penalties the statute could have imposed because you made clear you thought this was an improper, not public session. So, yep, that's what the statute says.
I don't think I understand that. So if you're voting to enter non-public session and one of the members objects, they don't. So are they then not able to attend the non-public session?
No, they're a member of the public body. They can attend. And so they do attend. They were not one of the people who voted in favor of, but remember, you only have to have a majority vote. And they're able to attend, and then they can make known their objection to it. So in a way, they're acting as kind of an agent in furtherance of the public's right to know by making clear this is not a proper non-public session. I'm going to be here to monitor what's going on, and I'm going to object. You have to state that and protect me from harm or from penalties that the statute could impose on other members of the public body. So it's this new provision, and yes, that's what it says. So I would always encourage you to return to public session after you've completed the non-public session, because when you return to public session, you really should then make a deliberate decision then. Are we going to keep sealed in minutes of this just completed non-public session, which is counterintuitive because you don't have the minutes in front of you, but you still have to do it. So the better practice is, and a lot of boards do it otherwise, a lot of boards just say, we're going to hold the non-public sessions at the end, and then we're just going to adjourn when we come out of non-public session. I don't think that's a great idea. I think the better practice is vote to come out of non-public session, convene in public session, and then make a deliberate decision. Are we going to seal the minutes? Because it would have an adverse effect on reputation if we release them, or it would render the proposed action ineffective, which is probably the more common one, or would have an issue disclosing our actions to thwart a terrorist attack.
So just to clarify, the discussion about sealing the minutes needs to be held publicly.
In public.
Gotcha, thank you.
So when you should state the reason you're keeping them sealed in your public minutes, or?
There should be a motion. And the motion should be, Madam Chair, I move that we keep the minutes of just completed non-public session sealed, because their disclosure would render ineffective the action we just took. One of those three reasons should state in the minutes. And by the way, they're not sealed permanently. They're only sealed temporarily because well, just let me complete one other set of things we have to keep in mind. Other considerations about non-public sessions, I would generally think it's a good idea to include them on the agenda. Now, since you don't always know whether you're going to convene a non-public session, so you don't know if someone's reputation is suddenly going to pop up as a concern for the public body, I think that the better practice is have the following on every agenda. And it would say very simply, this public body may enter into one or more non-public sessions as permitted by 91-A:3. Just put it out there for every set of minutes. So then you cover yourself if someone says, you didn't have that on the agenda. And so when do you do them? At the beginning of the end? It's really depends on who has to attend. If town council has to be there, because you can discuss pending litigation. They're very expensive. You don't want them sitting around for hours getting paid to do that. You might want to have it at the beginning of the meeting. And if you have to have attendance by other people, the assessor, town staff who have to pay it overtime, you may want to have them at the beginning as opposed to the end of the meeting. And then we have this new requirement effective January 1st. So effective January 1st, all public bodies must maintain a list of non-public session minutes that have been determined not subject to public disclosure. And that list has to include the date and time of the meeting, the non-public session, the exemption that was used, and the date of the decision to withhold the minutes from public disclosure, and the date of any subsequent decision to make the minutes available. So it's a spreadsheet you have to keep, and it's prospective only. So it only applies to non-public sessions that have been conducted from January 1st going forward. And then we have a new provision, which always made sense to me. Minutes related to a non-public session on the acquisition or sale or lease of property, they must be made available as soon as possible after the transaction has closed or the public body has decided not to proceed with the transaction. Again, it makes perfect sense. You decided not to buy that conservation land or other property, and so the discussion that happened in non-public session should then be disclosed. And I think I've got a minute, right, Jonathan?
Yep, and we're waiting for some questions.
Okay, can a board go into non-public session even in a non-public session is not on the meeting posted? Yes. Again, the better practice is just to put a blanket statement. We might have a non-public session if necessary. If a town is in a lawsuit with the applicant before the ZBA, can the board ask in public for information about this, or must it be in public? Do the questions in non-public? I'm not sure about your question, Sharon. We might have to follow up later on. maybe you could submit that to me in the legal advisory service. I'm not 100% certain what you're saying. So you have a question?
The second point about your transaction is complete. Is that an administrative decision that's informed the clerk to say release those minutes?
Preferably, yeah. I mean, if you know that at some point, someone's got to keep track of those non-public meeting occasions, the non-public sessions where you had that kind of discussion, and someone needs to keep track, did that transaction go through? And if you've dropped it, let me know so that we can decide whether those minutes are disclosable. So there is going to be a little bit of tracking.
And that would only be those minutes since January 1 of 2022, because you could have non-public issues on a land matter that goes for years back.
This is only prospective. Both of these requirements are only prospective.
So does this list that we have to keep need to be made public?
What list? Oh, yes, it's got a public list.
Yeah.
It has to be available so the public can monitor the non-public sessions, when they were held, and the reasons for keeping the record of the minutes of the non-public session non-public. That all has to be public record,
And
yes.
it's for all boards?
It's for all boards,
Okay.
all public bodies. So with that, I'm gonna go into a coffee break. And we'll convene again at 11 o'clock when Jonathan will pick up the governmental records. We're gonna have you have to stop the share and reshare.
No, it's still gonna go funky. I think I have to stop the PowerPoint completely and reopen it. Remember, we had to
Yes,
do that
right.
last time. Oh, so shouldn't be this difficult. Stop share. All right. Okay, bear with me, everybody. Fun stuff. All right, and then we gotta go to your slide. That
Right.
doesn't work, I don't think, because it's not plugged in. What slide number was it?
Just go to the right. Keep going. Stop.
Oh.
Okay, there you go. Right there.
There we go, all right.
He's gonna start the recording
Yeah,
first.
now I gotta, oh, it was going the whole time, so I
Okay.
did unpause it.
Okay.
Well, lucky people at home and where you guys watch the recording, you'll get to see all that.
Be a lesson in how to share, how to fix your share screen. That's pretty good.
Who needs new battery?
Oh, did you plug it back in?
Yep.
Okay, people at home, just bear with us.
We got little,
Let me get some new batteries.
see how they show to redirect it.
Oh, yeah.
One over by your.
You just want
Try
to
to
change
go ahead
slides.
and let Ashley forward it for you. She can do it.
I can just change slides for you until, just say
You
next
know what, in
slide.
that case, why don't I just do let me share my screen. It's just gonna be.
No, no. Oh, I don't think you can share your screen.
That's a dream.
Yes. You're not connected. Well, she said it.
You can pull up the PowerPoint though, if you need to, for your
Alright,
notes.
Ah, is that not work? Oh, okay.
Want me to change it?
All right, no, we're good. You want to start?
Sure.
All right, so we're gonna get started. Welcome back, everyone. Sorry for the technical difficulties. So this section is going to be on governmental records and the right to know law, as well as some of the exemptions to the right to know law. So next slide, Ashley. Okay, so RSA 91A4 mentions that every citizen has the right to make a public records request. And so within that, we have to define the term citizen. Oh, this is working now. All right, so the term citizen is a term that as of right now is not necessarily clearly defined. The courts are sort of discussing what it means to be a citizen, and there's an implication out there that the word citizen implies only a resident of the state of New Hampshire. That's not definitive though. So when it comes to our advice, the advice that we give at NHMA is that if somebody shows up to a public building in person and makes a right to know request that they want to either show up in person or set an in-person appointment, we consider them a citizen that's there for the purposes of right to know, and that you should comply with that request as long as it fits with everything else. It gets more complicated when you receive virtual or online requests. If you receive an email, especially from an out-of-state entity that's seeking right to know records. And so when that situation arrives, it's a little bit more complicated. Our advice, and I'll get into this a little bit more later in the presentation, but our advice is that when you receive an email or a request to send records virtually, especially over state lines, to always ask people to set up an appointment to come in person. And at least for now, until the term citizen is further defined by the courts, which hopefully it will be, that's the advice that we're giving. So
Is it before the courts?
there is a case that's pending about the term citizen. And Steve, I don't know if you know any more about that, sort of what the update is, but there's an issue going on right now where they're waiting to sort of define it, right?
I've not, it's been no definition, and all we have right now is a US Supreme Court case that ruled in a Virginia statute similar to ours that a citizen, the citizen right to have access to records is limited to citizens of the state of Virginia. And the court noted in that case that New Hampshire statute is similar to the Virginia statute. That's the closest we've gotten, but New Hampshire has not ruled out.
Okay, so when somebody makes a right to know request, they need to be sure that what they are requesting has been reasonably described. And this makes sense because the public official whose job it is to comply with that request needs to know what it is that they're actually looking for. And so this doesn't mean necessarily that just because a request might be vague or confusing that you can simply deny it. You need to make some reasonable efforts to figure out what it is that this person is requesting, so you can do an analysis to see if it's information that needs to be provided. Sometimes that might mean making a clarifying phone call or putting a little bit of effort into figuring out what it is that this person wants to see. And so the courts have provided a little bit of insight as to what it means for a request to be reasonably described. And so a reasonably described request would be sufficient if it enabled a professional employee of the agency who is familiar with the subject area of the request to locate the record with a reasonable amount of effort. For example, if an agency cannot categorically deny a request for an email simply and solely because the request does not reference the sender, recipient, subject, or time frame of that email. You would need to follow up with the person making the request to have them give you some more specifics. However, an agency need not honor a request that requires an unreasonably burdensome search. So it's this sort of reasonable balancing test as to whether or not it is or isn't reasonable for you to go through the efforts of figuring out what the person is actually requesting.
Jonathan, a quick question here. Does a request have to say it is under the right to know law in order to trigger the requirements of the right to know law?
Right. So, I mean, the advice that I would give is that I don't think it needs to explicitly cite RSA 91A and say that it is, a request under that statute. If it is, again, sort of this reasonableness analysis, if it is reasonably apparent that what the person is seeking is a government records request, a public information request, these are words that we sort of use interchangeably with right to know, that you should honor it as such.
The other point is the requester doesn't have the ability to sort of determine that, right? So it's on the municipality, not on the work. Like the requester kind of might want to avoid it, but if they're going down that path and you make that call, they don't get to say, well, that's not right.
So the requester doesn't get to say.
Doesn't. get to determine if it's not a 91 request or not, 91A request or not. It's the municipality that makes that call. They don't cite it.
Right. It would be a judgment on whether or not you think that the person has sort of articulated that. Do you have anything you want to add?
No, nothing further. But related question to the search process.
Right.
Jim Doggett asks, how many years of minutes need to be read to find a decision requested to be found? How far, how long, how detailed do we have to search?
So there's something in the slides coming up that I'll get to, but the standard is not whether or not the record in fact exists. It's whether or not it can be located with a reasonable amount of effort. So again, it's this term in the law, reasonableness. What is reasonable? And so it really kind of is a judgment call. But as long as you can establish that you have put in a reasonable amount of effort to find the record that is being requested, the courts have recognized that it doesn't necessarily matter if that record in fact does exist somewhere lost in the basement of a municipality building and in boxes and boxes. If you can show that you put in a reasonable amount of effort, that will satisfy the statute. Now, what satisfies the word reasonable, that's kind of up for debate.
The only thing I would add to that is, the effort, has to be reasonably calculated. So if someone has asked for minutes from the select board from the 1950s, and you do know that those records are contained in a particular storage area, you have to show you went to the storage area and you tried to find them, and you did some reasonable kind of, examination of stuff in there to find records from the 1950s, and if you didn't find them, you can demonstrate you acted reasonably in conducting that search.
So how do you prove that? So, for instance, our zoning regulations date back to, I want to say 1965, but for whatever reason, we can only find 1974 and beyond. I cannot find anything from 1965 to 1974. And I've looked in our whole department, I've looked in the town clerk's office where they keep the permanent record books. Nobody seems to have them. I've done an online search for the space that we use for, electronic files. I mean, to me, I've exhausted all my possibilities, but how do I prove that?
So that's a good question. So, and the way that I like to answer these questions, because we get a lot of questions like this of, well, what happens if there's a conflict of interest and it goes forward? What happens if I do a search for a public records request and I can't find it? And so the way that I tend to explain this is that, look at it in the context of what the remedy would be. So if you deny this request and then you play that out, what happens? Well, the person files a suit in court and says that so-and-so didn't comply with my request. And so I always think of it, I have a background in prosecution, so I was in front of a judge for everything that I ever did. So I look at it from an evidence-based standpoint. So what you want to do is you want to be creating sort of a trail of evidence that you can use to back up your decision. So if your decision is going to be to say, this record doesn't exist, or we weren't able to find this record, you need to have something to show that the reasonable effort was put in. And that's sort of that's the next slide. It's sort of what we were talking about. But my suggestion would be to make sure that whoever's job it is to search for these records, or whoever's putting in that effort, to leave a paper trail, to take notes, to take an accurate account of what was done. And then you could provide a signed affidavit that says, our computer system dates, stores electronic records back to this date. All other records after that are stored in boxes down in the basement. I spent X amount of hours looking in the basement and was not able to locate the record. So it really comes down to that sort of, again, it's like a judgment call as to what you think is a reasonable amount of effort, and then being able to provide an explanation. So ultimately, if you play it out, what would you give to a judge to show this is what I did to put in a reasonable amount of effort?
Thank you.
So we have a question: if someone comes into town hall and asks for something, even though it might be available rather quickly, can you ask the person to come back at a specific time? You might be understaffed, employee out, sick, vacation, and you are swamped with other things. So this is another thing that we'll get into a little bit later in the presentation, but records that are immediately available should be made available to a person who comes in looking for it. That being said, a municipality is can take reasonable steps to schedule appointments, to have people come in. If you were understaffed or there's other things going on, the statute provides avenues within reason to tell someone, you know, we've received your request. We need a couple days to gather the documents. It's not something that necessarily has to be done right away, with the exception of a few different things. You know, minutes being one of those, is that I think the statute says that minutes need to be made available within 5 days. So if you're within that time, the minutes should be readily accessible, you know, somewhere where you could just hand them to someone if they came in. So there are 3 key steps in determining whether or not something is subject to disclosure under the right to know law. So the first is step 1, determine if the thing being requested is a government record. Step 2, governmental records are subject to disclosure except as otherwise prohibited by the statute. So there could be exemptions in there. And then step 3, every citizen at the regular business premises and during regular business hours of public bodies or agencies has the right to inspect governmental records in the possession, custody, and control of such public bodies and agencies, and to copy and make memorandum or abstracts of the records or minutes so inspected, except as otherwise prohibited by the statute. So those are the 3 key steps, and I'll go into defining them a little bit further. So the first is whether or not it is a governmental record. So this is 91A:1-A. Only government records can be subject to disclosure under the right to know law. So start by determining whether the thing being requested is in fact a governmental record. And so under 91A:1A, a government record is any information that is created, accepted, or obtained by or on behalf of a public body or a quorum or majority thereof, or a public agency, and in furtherance of its official governmental function. This can include any written communication or other information, whether it's in paper or electronic format or other physical form received by a quorum or a majority of the public body in furtherance of its official function. Whether this was something that was created or generated at a meeting or even outside of a meeting, if you had some of the things that Steve was talking about, you had a quorum or a majority present, and that the information was produced or created in furtherance of that body's official government function. It's also important to note that the information needs to be a record. It can't just be some sort of abstract form. Like they're physically, it seems sort of obvious, but there needs to be something that can be provided, whether that's you know, in an electronic format, a paper format, or otherwise. But there has to be something that actually can be provided to the person, and that the term governmental records also includes the term public records. They're generally used interchangeably. So here are some examples of electronic records. This can be confusing sometimes as to how electronic records fit into right to know. So governmental records can take many different forms when it comes to electronic records. Some of the examples that we often see are documents that are stored in a computer or other storage medium, such as a CD, DVD, cloud, thumb drive, external hard drive, emails and voicemails, PDF documents, instant messages, text messages, emails, electronic photos. All of those things can be considered a governmental record and subject to right to know. I have a question that says, if a log of 91A requests is kept by staff, is the log itself subject to disclosure? Yes, that is a record that is produced by a government body in furtherance of its governmental function. So I would say that yes, that would also be potentially subject to a 91A request.
So we're actually in the middle of a right to know request right now that we're gathering information on for a specific planning board case. Does this mean that we should be including because we record our meetings, that I should be recording like giving them some sort of link to the meeting from YouTube or what, however, like the actual meeting itself, the recording of the meeting?
So if someone's making a right to know request for the full recording of a meeting.
So the right to know request is regarding everything for a specific case that's before the planning board, everything.
Okay. And one of those things would be like the recording.
So yeah, obviously the meeting was discussed. I mean, the project was discussed in several planning board meetings. And I'm just thinking in my head now that I did not include those planning board meetings, and I'm thinking I should have.
Okay, so I'd see if you have an opinion on that.
So you have a right to know request
Mhm,
relating to anything touching on a particular application.
correct.
And they're looking for not just what might be in the planning board file, but anywhere else at town hall.
Correct.
So you have a recording of a meeting where this was discussed.
Several, yes.
If you still have the recording, you probably have to provide that recording.
So how do I have to provide it? Because they're actually still available on our Merrimack. Told you where I was from. Our media's webpage on like YouTube. Can I provide just a link, or do I
I think you
actually?
could provide a link.
Okay, all right, great, thank you. Sorry to be so specific.
Yep.
So you mentioned instant messages and, we have some departments, but not all within our municipality that communicate via Teams, Microsoft Teams. My understanding is that they don't have access to the logs of those instant messages. If there was a request for the instant messages, what would the reasonable search be? Would it be contacting the, Microsoft or however we've contracted to have this service?
Right.
And say, hey, can I have the logs of these instant messages for certain dates?
So I think, and Steve, you can correct me if I'm wrong that, so to an extent, that could be considered having to compile something that doesn't necessarily exist if they don't have it.
Well, I guess I would say this, I know enough about Teams because we use Teams. And we have an internal policy that all the messages are deleted for a certain period of time, it's not required to be retained. But to the extent you have them, Teams is a very simple function of extracting the exchange of communications to the chat function. So it would just be a matter of extracting and downloading a copy and making it available either electronically or just to print it out. So I think you would need to find them and make them available.
Right, if they're saved in your system, right, in a way that you can access them. Accessing deleted, Teams information that would be deleted, if your Teams deletes conversations after 6 days or whatever.
Which is the
That's
better practice, by the way.
Yeah, same thing with your
Right.
recordings too. Once you get your minutes.
To delete them.
You can have a policy about destroying recordings of meetings, as it's a draft, all the drafts.
right, and so with the Teams example, technically, you could request from Microsoft or law enforcement could get a search warrant for Microsoft to see if they keep records of it, but that's not something that's in the possession of the municipality, so it's not something that you have to provide pursuant to 91A.
And there's a question here also, Jonathan, are phone call logs subject to disclosure? I don't know what kind of phone log, but I think, yeah, if you keep a log of phone calls coming in and out of, say, the police dispatch center, that's subject to disclosure. Now, there's another statute that deals with E911, and what's not subject to disclosure there, which those are exemptions, and Jonathan will help that in a bit.
And so that's where we're getting to right now is, so once you've determined whether or not the record is a governmental record, the next question you have to ask is the record or any part of the record exempt from disclosure under one of the many reasons why some information could be exempt. So first off, there's certain information that is mandated access to by the statute, certain records that are specifically mentioned as accessible to the public. Those are the RSA 91A4, paragraph 1A imposes a very specific duty to disclose and make available for public inspection any payment made to a public employee that is in addition to regular salary or an accrued vacation, sick, or other leave payments made during the normal course of employment. So additional added payments are specifically mentioned. After the completion of a meeting of a public body, every citizen during the regular business hours and at the premises has the right to inspect all notes, materials, tapes, and other sources used for compiling the minutes of the meeting and to make any memoranda or copies of such. And then finally, every agreement to settle a lawsuit against a governmental unit, a threatened lawsuit, or other claim entered into by any political subdivision or its insurer must be kept on file at the municipal clerk's office and made available for public inspection for a period of no less than 10 years from the date of the settlement. So those are a few things that are specifically mentioned. All right, so exemptions to disclosure of governmental records. These are mainly covered in section 5, 91A:5. So 91A:5 provides a list of records that are categorically exempt from disclosure. Those are things like the master jury list, teacher certification records. There's a list of things that are by category exempt from right to know. Some statutory exemptions require a detailed analysis, such as whether those records would constitute an invasion of privacy. That's the most common exemption that we see. The next slide we'll deal with that, and I'll get really into the sort of the balancing test because of how important it is about an invasion of privacy. It's important to remember that the right to know law's purpose is to provide transparency in government. That's why it exists. It exists so that citizens can obtain information about how their government entities are functioning. And so we look at right to know requests always with an eye towards disclosure, because that's sort of the essence of that law. And when a public body or agency seeks to avoid disclosure for whatever reason, there's a pretty heavy burden on the municipality to explain why they are not complying with all or part of that right to know request. So 91A:5 paragraph 4 is the most common exemption. And this is the language of the statute, but what it really comes down to is that last section, which talks about whether or not providing the information would constitute an invasion of privacy. And so this term invasion of privacy has resulted in a decent amount of litigation and some case law that has ultimately resulted in this privacy interest versus public interest balancing test. And so we have a few other exemptions in there that are worth mentioning. So the internal personnel practices exemption, this is RSA, again, in the same paragraph, 91A:5, paragraph 4. This exemption applies to government records that pertain to rules and practices dealing with employee relations or human resources, including the hiring, firing, personnel rules, discipline, and compensation and benefits. There's been some recent reinterpretation of this by the Supreme Court. Formerly, internal personnel practices was a fairly broad categorical exemption, meaning anything that could be considered a part of an internal personnel practice was exempt. The court backtracked on that and has now essentially concluded that even things that would be considered an internal personnel practice are still going to be subject to this balancing test. We have a slide, these next couple slides deal with some cases that address this, with the last one that I'll get to being Provenza versus the town of Canaan was actually just released on the 22nd, I think. And that sort of solidified this concept about internal personnel practices that we were talking about. So this case, the Union Leader versus Salem, describes this privacy balancing test. It talks about how this is sort of the first case where if something is considered or classified as an internal personnel practice, then whether such records are subject to disclosure depends on evaluating whether the disclosure will constitute an invasion of privacy. So first, you have to ask whether or not a privacy interest exists. So you look at the information and ask whether or not sort of a reasonable person would consider disclosure of that information to be an invasion of their privacy. If a privacy interest does exist, then you move on to the next question, which is what's the public's interest in this knowledge? And so, or in obtaining this information. And so the important thing to remember there is that the public interest is a much broader idea than just, does this one member of the public have an interest? So people have interest all the time personally in finding out whether, what another individual was up to, or why the police were at so-and-so's house or something like that. That doesn't necessarily mean that the public as a whole has an interest in knowing this information. What the public interest is whether or not the information being disclosed shows the public that their government entity is operating as it should. The public interest is in the government entity, not necessarily the individuals or the individual person involved in that. And then finally, once you've determined if there's a privacy interest and what the public interest is, you balance the two to figure out whether or not disclosure of that information would be an outweighing violation of that person's privacy, or if the public has a compelling enough interest that warrants disclosure. And so this decision had some wide-reaching implications, and that's where we get to this Provenza case. So just briefly, in the Provenza case, what we had is a police officer who was on duty. He arrested a citizen, and the citizen then filed a excessive force complaint against the officer, saying that claiming that he used excessive force during the arrest. The police department hired an independent agency to do an evaluation and determine whether or not they felt that the officer did in fact use excessive force. And that agency issued a report. A newspaper then filed a right to know request seeking the report. So at first, the police department denied the report, claiming that it was part of an internal practice and using that categoric exemption. That was sort of amended once the Supreme Court made some of those other decisions, subjecting the information to a balancing test. And so ultimately what it came down to was whether or not Officer Provenza here had a compelling enough privacy interest in the outcome of that investigation that outweighed the public's interest in knowing how the police department handled this excessive force complaint. And so the court essentially ruled that the public has a compelling interest in knowing whether or not their police departments are policing their officers appropriately, whether or not they're doing a good investigation into complaints like this against police officers. And even though Mr. Provenza may have had some type of privacy interest in keeping the results of that report private, whatever interest he may have had was greatly outweighed by the public's interest in knowing how the police department handled this complaint. And so ultimately, the report was releasable under RSA 91A. So there's another issue that tends to come up, and that's confidential commercial or financial information. So every once in a while, a town or a city will get generally considered private information about a private business. Some of that information can be sort of a market analysis of potential condominium sales, balance sheets and income statements of real estate developers, commercially generated credit reports of real estate developers, a letter of credit issued by a real estate developer, a construction finance activity sheet, rent and credit income information, or a development agreement and construction loan agreement between the real estate developer and, say, the New Hampshire Housing Finance Authority and private lenders. So this is information that generally would be kept by private entities and not subject to disclosure to the public. However, once a municipality becomes in possession of that information, that changes things. And so just because that information is generally considered private, or even if a municipality used sort of a statement that it would be confidential, doesn't necessarily mean that it's exempt completely from RSA 91A. So the emphasis is placed on what the potential harm would be of disclosing that information, harm to the private company in this case, versus the benefit of public disclosure. That's the test that will be used to determine whether or not this information is subject to a right to know request, not whether there were statements made that it would be confidential or information that's generally kept confidential. So other files whose disclosure would be an invasion of privacy. So there's a list of what's considered inherently private information from the AG's office. They do have a memo that's online. It's a little bit outdated, but it does have some useful information on there that's still relevant, including what stuff that you should pretty much always redact pursuant to a 91A request. Those are things like people's date of birth, their place of birth, social security number, New Hampshire's driver's license or ID number, medical records or information on someone's medical condition, psychiatric records or information, and educational records. So it's things that, if this is information that could be used for identity fraud, right? If it's someone's mother's maiden name, you probably want to redact that. That's stuff that people could use to, cause financial harm to somebody else, or things that are generally considered private and would be considered private even under a different standard like HIPAA for medical information. The New Hampshire Supreme Court has also said that the right to privacy includes an individual's right to this concept called practical obscurity. And what practical obscurity generally means is that if even if information is technically publicly available somewhere else through maybe like a detailed Google search or something like that, if it's if it's information that is generally felt to be considered private, it could be practically subject to practical obscurity. So the example that's used is that even though it was an elected official's home address could be found through other means of public record search, that information, your home where you live, is generally considered practically obscure. It's not something that is readily sort of obtainable just by, you know, the usual means of obtaining it. And so that could be considered something that would be redacted. Before I get to this, so
Even though I could find like right on the checklist or something.
right, so it's kind of it's a judgment call as to how difficult it would be to find it. And I guess the real emphasis, and Steve, I don't know if you have anything you want to add on practical obscurity, but I would describe it as it depends on the effort that needs to go into finding it. Like there is some information that is available out there publicly, but would require a decent amount of effort or maybe some technical knowledge to find. And so that sort of is what would be considered practically obscure.
Well, the other thing that I think, let's assume a set of pieces of information municipality has, which arguably would be subject to, would not be disclosed because there was a significant privacy interest. If the agency was trying to decide whether to release those records and said, well, we have the records, and even though we have them, we wouldn't release privacy reasons, maybe we should release them because I can go to Facebook and find the same records. And I think that's what that case is about. Even though the records might be available someplace else, easily accessible, you still have to go through the analysis for the town part of that record, or the town element of that record, or the part of the record you have, and make that separate decision. Is it subject is it exempt because it's sufficiently private, isn't sufficient public interest? I think that's really what the obscurity is, that you have to make your own independent judgment as whether you have a duty to protect the privacy of the individual.
So just a note on a couple other documents. So election documents, the courts have ruled that these can be subject to disclosure, including a candidate's application for office, letters of recommendation, and score sheets, if those are accompanied with an application for office. In this case, it was a application for a county sheriff. The courts ruled that those documents are subject to disclosure under 91A. Public employee salaries, specific names and salary information of public employees are public, and disclosure does not constitute an invasion of privacy. That was from a case, Mans versus the Lebanon School District. And then personnel files maintained by a public body or agency are not per se exempt. That's what we've been talking about. You still have to provide or go through the balancing test for that. So we have drafts and notes. Yep, your question.
This is kind of a mixed question from an earlier conversation. So there was a statement that was made about non-public meetings and disclosure of compensation for employees, and that can take place in a non-public meeting. Can that take place in a non-public meeting if we're talking about, you know, compensation of increased salaries for an employee, or should that be done publicly in a public meeting because those have a right to disclosure?
Steve, do you want to answer that because it's
Okay,
a
so
non-public?
the select board is having wants to have a meeting to consider whether to increase or decrease the compensation of a public employee. That can take place in non-public session.
Okay, so but the disclosure of what is decided at that meeting should be.
The disclosure, they could keep that discussion non-public. However, when the employee gets paid, what the employee gets paid, their gross salary is subject to disclosure under the right to know law. So it could come out later, but not necessarily how the board decided what to pay that person, which would be in the minutes of the non-public session.
Okay.
So the comments as to why this person should or shouldn't get a raise may stay sealed in the non-public minutes, but the ultimate, you know, end salary and the name of the employee would be disclosable. Okay. So when it comes to drafts and notes, there's a case on this. It's ATV Watch versus the New Hampshire Department of Transportation. This case talks about how handwritten notes, personal notes in the margins of a letter, or like sticky notes with handwritten notes on it, that those are considered personal notes and they wouldn't be subject to disclosure. In addition, drafts of letters are not necessarily subject to disclosure. The final letter would be, but it's important to remember that if that draft was passed around to a quorum of the public body and people were given input on it or something like that, that could change the analysis. But a simple draft that then ultimately ended up in a final version, the final version would be subject to disclosure, the draft not necessarily. So law enforcement records kind of.
Just before you go there, Jonathan, there's one other question. It's kind of related to just general disciplinary records. Does the public have a compelling interest to know disciplinary records of all employees, town administrator, road superintendent, staff secretaries, clerks, etc.? What is the, well, I guess really asking, we have all these records about other prior disciplinary actions against employees. To what degree are they subject to disclosure, or are they, exempt from disclosure as private under the private surveillance capacity?
Oh, I guess that's a good question, and I think it will come down to a case-by-case judgment call as to, you'd have to look at each individual scenario. Disciplinary matters involving employees are things that, that's one reason why you could go into non-public session and have that information sealed, have the minutes sealed so that information is not made publicly available. But I think in this case, information about disciplining an employee, just about every one of those employees would have a privacy interest. So, people generally don't want their employer disciplining them to be known to the public. So the next question would be, what's the public interest in disclosing that? And I think that's where you're going to have to look on a case-by-case basis. Well, why is this person requesting this? What is the sort of the purpose of this 91A request? And that can get a little tricky because you're not really supposed to ask what the purpose is of it. But for the balancing test, you can make that inquiry to decide what the compelling public interest is. So if this is a private citizen trying to dig up dirt on another private citizen that they maybe don't like, I don't think that there's a compelling public interest there. And I think most people would analyze that there isn't an overall compelling public interest. But if the interest is to find out whether or not the town is, taking complaints against an employee or employees seriously, and whether or not they're, addressing maybe a systematic issue that's going on within the town employees, that could be a different story. When it comes to that analysis, there may be information that could be disclosed, subject to certain redactions. And so it really comes down to that balancing test. And I think to this question, if somebody made sort of a broad request for disciplinary records for all employees, that might be one of those situations where they haven't really established a broad enough public interest.
And the only other thing I would say is that the Provenza case had an interesting twist on that analysis. What the Superior Court judge said, which has now been affirmed by the Supreme Court, was that there would be a significant privacy interest which might justify not releasing the record if the disciplinary action by the community, or at least the disciplinary investigation, the town of Canaan, dealt with matters involving the private life of the police officer, and had nothing to do with the police officer's job as a police officer. So there was a distinction drawn there. The disciplinary investigation was dealing with on-duty versus off-duty conduct. So that would be one of the things where, in that instance, I think the Superior Court judge would have said, well, we were just trying to determine whether or not, the officer had inappropriate extramarital affair. That's irrelevant to his public duties as a police officer, and that would not be subject to disclosure. But I think Jonathan's right. You still would have to look at these requests for disciplinary records. I mean, if I just don't like the road agent and I just want his disciplinary records, that may not have an adequate public interest. But if I've been making repeated complaints about the fact that the culvert at the bottom of my hill has failed and the road is crappy, and there's lots of other complaints and nothing's being done about it, or maybe there's a disciplinary record and no action is taken. Now I think there's established a basis. There's a public interest to know what's going on, what is the community doing to make sure that the road agent is doing his or her job. So I think that's kind of the analysis that Jonathan's suggesting. It's going to be individual circumstance to assess each case to decide whether the balancing test justifies either disclosure or non-disclosure.
And Steve, what's the case? It's state police versus.
I'm drawing the blank.
Yeah.
There was.
So there's a case where somebody made a right to know request to the state police, requesting any documentation that the state police had involving an individual. That individual happened to be a member of the school board. And so the state police responded to that request by saying that they would neither confirm nor deny the existence of any records. And they argued that that was the appropriate response because what this school board members' activities were, whether or not the state police had any activities with this school board member, was private information. Even though we were talking about a public official, this request did not focus on something that they were doing or are not doing in their capacity as a public official. It was somebody looking for essentially dirt on a private citizen. And the court actually upheld the state police's response by saying that it was the appropriate response to neither confirm nor deny the existence of records, because that was the only way to protect this person's privacy interests. And the fact that it was a public official that the records were being requested for didn't matter, because they drew that kind of distinction between, well, their interactions with the state police, if any, would have been in their private capacity as a citizen and not in their public capacity as a school board official. So when it comes to
I think that was Welford.
Welford versus state police.
Yes,
Thank you.
Welford for state police, yes.
So when it comes to law enforcement records have their own sort of analysis that needs to be done for release of records. And so that's because whenever we're talking about a law enforcement record, there's different constitutional rights that come into play. For example, the person's right to a fair trial, that's sort of the biggest one. So whether or not a law enforcement record, and this is generally, we're talking about police reports, but it could also be other records, whether or not they're subject to disclosure pursuant to a 91A request at that moment will depend on whether or not there's an existing criminal matter going on. If there is, those records are essentially exempt because releasing them could potentially interfere with a person's right to a fair trial. It could interfere with the defendant's constitutional rights. It could also interfere with a person's privacy interests. It could disclose confidential sources. So if it does any of those things, those records would be exempt. Under factor E, it's also important to remember that if disclosure of a law enforcement record would disclose investigative techniques or procedures, those could be exempt. So a good example of that is if your town's police department has a use of force policy, that can be exempt, because providing that to the public may give someone who is potentially thinking about committing a crime information on how far they could push an interaction with police before the police use their taser, or before they shoot them, or something like that. So that's an example of something that would be exempt under factor E, or even under factor F, which is endangering the life or safety. That would be the life or safety of an officer or of another member of the public or something like that. So when it comes to law enforcement records, it's important to make sure to go through that more in-depth analysis. It doesn't come down to just this privacy balancing test. There are other factors that need to be considered. A note on body worn cameras. So there was a new law that became effective in 2017. It doesn't require law enforcement agencies to use body worn cameras, but if they do, they have to abide by the procedures. More and more towns are now using body worn cameras, and they're becoming more popular. I don't think it's long before just about every department uses them. So if your department does use body worn cameras, then RSA 91A5 paragraph X deals with that. It talks about how video and audio recordings made by law enforcement officers using body worn cameras pursuant to RSA 105D, which is the statute for the body worn cameras, except as are not required to be kept. They can be written over, except if the recordings depict any of the following: any restraint or use of force by a law enforcement officer, provided that this exemption shall not include those portions of the recording that constitute an invasion of privacy. So we're still looking at the privacy interest. The discharge of a firearm, or an encounter that results in an arrest. So if the law enforcement officer shoots their gun, arrests someone, or uses force, Those recordings need to be kept. The statute will go into, goes into detail as to what to do with that. Everything else, you're allowed to have the recordings be recorded over on sort of a continuing loop. A note on IT security, there's another exemption within RSA 91A5 that allows municipalities to not disclose information that would subject their IT structures to potential cyber attacks. It's a very narrow exemption, but basically, if disclosure of that document or that information would assist someone in gaining access to your IT security, that information can be redacted or exempt entirely, depending on the document. So then we have the attorney-client privilege. So as of right now, it still exists. There is some legislation pending that seeks to undo that, even though it was just done recently. But as of right now, 91A5 still has an attorney-client privilege exemption, which means that any information that could be deemed protected under attorney-client privilege is not subject to disclosure under RSA 91A. And so that could include any information that could tip off sort of what the subject matter was of a discussion with an attorney. So that's obviously communications, written or electronic communications. And it could even go as far as sort of a summary on a billing statement of what was talked about, or potentially even the name of the case that was being discussed. The things that would be disclosable would be the fact that a municipality consulted with an attorney and what was billed. So the advice that Steve and I have been giving is you can disclose that the town consulted with an attorney on such and such a date and that they were billed X amount. But if there's summaries of the discussions or anything that would give information about what the context or content matter of that discussion was, that can be redacted.
So I have a budget committee who is able to ask for more detail and information about things that are in their budgets, of course. So the question that they have is, why are we going to legal? So they've been asking a lot of detail about, can we have how much it cost, what they went to legal for, when they went to legal, who approved the legal. So how much of that disclosure can we say, unfortunately, all we can really give you is the total amount of the cost and when the occurrence happened? Is that really all we can provide the budget committee while they're asking that question of because they want to know how many times planning board has been asking for it, or how many times select board has been asking for legal or the TA and what about it? So because an official budget committee can ask for as much detail to some extent, so I got you stumped, okay.
No, I mean, I don't think we're stuck. I think Jonathan has already basically said that, if you are asking for copies of legal bills, you can certainly disclose the occurrences of asking for legal advice and the amount that was charged, and you can provide that to the budget committee. But if they're asking when the planning board asked about specific cases, they're endangering the attorney-client privilege. Now, there's a whole array of case law that governs who's considered part of the governing authority of a public body who can be allowed to have access to attorney-client communications so that you don't breach the attorney-client privilege. The budget committee has to understand there are certain things that cannot be disclosed because the attorney-client privilege was breached. It may breach it for a lot of different areas which are harmful to the community. But providing the budget committee a summary of the activities of town council for different departments, the amount charged, that's okay. I just would not think it's a good idea to disclose the specific matters if that has the potential of breaching the attorney-client privilege. And the budget committee has to understand that. Because if they really want to spend a lot of money on legal, breach the attorney-client privilege and now allow the town having to hire someone to defend the town against release of information, it's going to get really expensive.
Yeah.
And they don't want that.
But couldn't they give basic information? It sounds like the budget committee might be seeking to find out if they're inappropriately using legal counsel to make decisions that they should be capable of making themselves the board.
So I mean, that information is not really, release of that information, I think would violate attorney-client
You
privilege.
think so? So even if it's just like, oh, the board sought legal counsel 6 times to ask about, I can't even think of something off the top of my
Well, what are
head.
the appropriate standards for granting a variance?
Right,
What is a hardship mean?
right, and stuff like,
That's getting into the attorney-client communication,
right.
and that's going to disclose the nature of the advice and result in the people who are on the other end of the transaction trying to use it against the town in court, argue the ZBA acted in bad faith, and now the town is going to have to pay someone else's attorney's fees by statute can occur if you act in bad faith. Because if the ZBA was told that's not hardship, but they did it anyway, or did the opposite, and they can prove that in court, now it's bad faith. Now you got to pay the other side's attorney's fees. You don't want that. So it can get really expensive to disclose the content of the attorney-client communication.
so, but even if it's general and it's like, we asked 5 times about hardships and not specifically this case, this case, this case, this case.
There are always gradations of what, as you're moving closer to that line at which a judge would say, you've just opened that discussion to the attorney-client privilege is breached here. So I guess you never know exactly what point have you crossed the line where the information is now no longer protected. And I think you just have to avoid getting too close. So I would say if they want to know how many times the ZBA asked, what is the definition of hardship, I would not recommend that be disclosed. I think that's inappropriate.
And as attorneys, we're very cognizant of the attorney-client privilege, and what we're concerned about is what it's called in the law. It's a slippery slope. So once you've intentionally or accidentally waived your attorney-client privilege, that then makes it a lot easier for somebody to argue that they should be able to pierce that attorney-client privilege in the future. And so if you start setting this standard that we're going to start giving a little bit more information, that could come back and bite you at some point when you get to information that you don't think should be disclosed because it's very much protected. It's black and white. It might not be black and white anymore. It might be gray, and then you could have a problem. So it's important to know that the very sort of the essence of 91A is that you need to make non-exempt records available. So municipalities have a duty to make non-exempt records available. And so the basics of record production. So the right to know law does not direct that records are to be provided immediately upon request. And this is sort of to that question earlier. Records must be provided when they are immediately available for release. Right to know does not give citizens the unfettered right to review governmental records in any quantity and wherever kept immediately upon demand. Public offices function more efficiently when when their record keepers plan their days around something like this. That's why it's completely reasonable to ask for a pre-arranged appointment, to have somebody set up a scheduled time so that the records can be available right there for them. Everything can be set up. The right to know law does not require the officials to explain why the record was not immediately available if the official provides the citizen with a record that is available within 5 days. So that's kind of an important concept. And I'm about to get into the 5-day requirement. The 5-day requirement is something that can be confused because you don't necessarily have to produce a record within 5 days. You have to produce a response within 5 days. But if the record is available, you have 5 days to produce it. And you don't have to explain why they can't see it right now, right at this moment. You can say we need an appointment within the next couple of days. There's a case, New Hampshire Civil Liberties Union versus the City of Manchester. In this case deals with the fact that municipalities are not required to compile records that don't currently exist in a compilation. So in this case, a requester sought all photographs taken by police officers of people who were stopped in traffic stops but not arrested. This information was not something that was kept in a compilation as the person was seeking. These records may exist. There may be photos of individuals that were taken, whether it was like through the body camera or something like that, that existed within the police records, but it did not exist in this compilation. And the court ruled that the agencies are shielded from having to create a new document in response to a right to know request, but it does not shelter them from having to assemble existing documents in their original form. So what that means is that if this information exists within records that are available, the person who wants that information can come down, set up an appointment, and they can go through the files themselves to find the information that they want. It does not require some person at the police department or at the town clerk's office to do that for them. So compile is defined as to collect and assemble written material or items from various sources into a document or volume or a series of documents or volumes. Before you provide information that if there's exemptions in there, make sure to redact it and make sure to redact it properly. It's just a note that we like to give that blacking something out with a Sharpie doesn't necessarily actually redact that information. If you hold it up to the light, you can really most times still see what's there. The best way is to black it out, make a copy, and then provide the copy, because that way you'll have actually protected the information that you sought to redact. No flat fees. This is a question that we get a lot as to what fees can be charged for providing copies of information pursuant to right to know. So there's been a lot of litigation and a lot of decisions on this as to what constitutes a flat fee. And ultimately what it comes down to is a fee is reasonable if it is the actual cost of producing that copy. So, 50 cents, 25 cents for the page and the ink. There's a case out there that actually the court found it reasonable for a municipality to work in a small charge for the fact that they leased their photocopy machine, that additional fee for the leasing of the machine was part of the actual cost that municipality incurred in producing copies of records. But you can't have a flat fee. It can't be $25 to get a police report or something like that. It has to be what the actual cost to produce that record is.
So your example is appropriate or not? The 50
It's
cents,
appropriate. It's appropriate.
that's appropriate.
Right, that was
50 cents
deemed
per page.
reasonable in that case.
Yeah, but the flat fee, if you establish it through code, like an ordinance, so if it's actually established under law, like,
A specific.
because we have like police reports that it's a flat fee of $15, but it's established in the code.
Right, so that violates 91A.
What code?
City code.
City code.
That
So
doesn't
city
work.
code.
No, you can't do that.
If a city clerk by statute is required to charge X dollars by state statute for a vital record, that's a different
Right.
story.
Or the checklist.
Or there is some by statute, you can charge a specific amount.
So I
And if
get,
your city code says, we're gonna charge you flat fees, that's a problem.
and I've got that question a bunch from police departments especially. They say, oh, we have, all you gotta do is log in online, you pay a $25 fee per police report, it's established by our policy, our zoning ordinance, that violates RSA 91A, you can't do that.
But RSA 91A says that if otherwise established by law, and it doesn't distinguish state law versus
No,
local.
that's not gonna work. It's otherwise established by state statute. It does not allow a city to have a code and then say that's otherwise established by law. That just doesn't work.
We need to tune up our attorney.
Well, no, I really think that's.
Since we did that a long time.
Yeah, it's gotta be, and there are statutory copying fees in certain instances.
Sure.
But that doesn't apply to the city having a code implementing its own statutory, so-called statutory copying fee.
What about labor in producing the copies of people? No?
No, so it is the actual cost, the court has defined it as like the actual cost to produce the record in like the paper, the copy machine, the ink, things like that. What falls within a reasonable fee for that. You can't say, it took Pam 20 minutes, that percentage of her salary is $8, so I'm gonna attach that.
And just so you know, we NHMA tried to get the right to know law amended to allow us to charge for the cost of staff time, and that was not approved. So it's very clearly not been added to, even though we requested.
And that's a problem that we're getting municipalities that are saying, we may have to hire a full-time employee just to deal with the volume of right to know requests that we're getting. And so, it's an issue, but right now it's an issue that is not provided a remedy for in the statute. We have a question, it says, isn't the copy machine owned by the public? Remember, record is created by an employee whom the public pays on equipment owned by the public. Why the extra fee? So I guess, yes, in essence, the photocopy lease is paid through, money which is gathered through tax dollars, same with the, the clerk. But I think, and Steve, correct me if I'm right, it goes to this sense that you can't use public dollars to pay for a private benefit. And so when we have one person, this private citizen is requesting a right to know, they're now using taxpayer dollars to get themselves a benefit, the pieces of paper and the photocopy. And so the court has ruled that it's appropriate for towns to take into consideration that cost to the taxpayer to service this private individual, and reasonable fees for reimbursement are appropriate.
Yeah, plus the legislature has said that the town, the municipality can charge the reasonable cost of additional copies, right in the statute. And if you took away that and said anyone can ask for any copies in any amount at any time, you have a significant increase in local municipal operating costs. So having a per page cost for a paper copy of a document, it's reasonable, and the legislature agrees. So that's where we are today.
Okay, so this, the next slide is on electronic records and sort of fees associated with producing electronic records. So RSA 91A4 paragraph 4 says that no fee shall be charged for the inspection or delivery without copying of governmental records, whether in paper, electronic, or other form. And so one of the questions that comes up is, well, what if the records, the person seeking electronic records that are already in an electronic format, and they want it put on like a flash drive or a CD or something like that? In that instance, the cost associated with providing an electronic record, if the municipality, for example, provides the disk or the flash drive, that you could charge a reasonable fee for that, electronic medium, right, that's being given to a person. But this issue comes up, and it creates sort of a bigger concern that we talked about when it comes to responding to requests for electronic records. And so there's a case on this. It's Green versus SAU number 55, which states that if the records exist electronically and the requester wants them electronically, and it is reasonably practical for the municipality to do so, then the records must be sent electronically. And so this case doesn't appear to require municipalities to put documents that are not already in electronic form into electronic form if that's what's being requested. But if they already exist electronically and it's easier and it's reasonably practical for the municipality to do so, they should be providing them in the electronic format if that's what the requester is asking for. Now, how do we reconcile this with the out-of-state requests? Like you get an email from some company that's in Massachusetts or Connecticut, and they're saying, provide me this information and provide it via email. And this is, again, it kind of comes back to this issue of who constitutes a citizen. It is still our advice that when you get a request like this, to ask for the person to come in person to view the records. Once they're there in person and they viewed the records, if those records are in electronic format and they want a copy produced electronically, then produce it electronically at that point. We give that advice because we have seen sort of an influx in these requests from these out-of-state entities seeking these records under this right, under the public records or right to know. And as soon as people say, sure, set up an appointment to come view the records, that's the end of the request, and you never hear from that person again. And so that's the best way that we've come up with to sort of advise on how to handle this, is that set an appointment, have the person come in and view the records at the town hall or wherever they're kept. And then if they want them in an electronic format and the records are already, on the computer or something and can be easily provided, then you can email them instead of making photocopies or something like that.
What if they push back and say they can't, because obviously they're from out of state?
Well, the statute specifically says that the records are to be made available at the place where they are regularly kept. And so there is no language in the statute that suggests that somebody can have the records simply sent out without having them made available at the place where they are kept. So that's.
We get that often. We run into size limitations with sending emails out that are that large. And it becomes
Right.
Problemsome, yeah.
And so, and I guess the other piece of this is, and this can get a little bit complicated, is that obviously, as a municipality, you want to be accommodating, especially to your residents. So when, you know, Tom down the street says, hey, I'm looking for this record, can you email it to me? If you say sure and just email it to him and don't require him to come in and take a look at it first, it's this sort of slippery slope argument again, where you could be setting a precedent now that your town is fine with sending out electronic records like that without requiring them to come make an appointment. And then what happens when you get an out-of-state entity, or you get a situation where you know, the file is too large to send electronically, and so you would normally have to have that person come so that you could print it out and send it to them. So you know, that's why we recommend adhering to the language of the statute, which says have the records made available at the place where they are kept within the municipality. And so that's going to be your best protection against some of these more like predatory 91A requests that could come, and we've seen an increase in them.
Does it make a distinction if the requester doesn't say 91A and they just say, can you send me a set of minutes from your last council meeting? And we send it, they don't say right,
Yeah.
they don't say anything like that.
So I mean, I think that kind of goes to that question earlier, as to whether or not, you know, a reasonable person would view this as a public records request. It's not, there's no requirement in the statute that says that you have to say, I'm making a request under 91A, I'm making a right to know request. If they are requesting public documents, and minutes is a good example, because I mean, minutes are public, like other than sealed minutes are about as, you know, the poster child of public record as you get. So that's obviously a request for public records, and it would fall under 91A. So I don't think that you need to, or that you can, you know, ignore that request or say it's not a valid request because they didn't cite it. I think you have
Yeah, I'm
to.
just suggesting we would send it electronically. Going down the slippery slope you're talking about.
Oh, if you
Someone asked
receive.
for a set of minutes, we just email them.
Right, so, and again, that's kind of that, if this is a resident in town who you know, you want to be like, sure, I'll send you the minutes, you don't have to come down. But I don't know if that's the best practice. It's kind of a judgment call, whether or not that's the best thing to do, or to say, sure, they're available at the town clerk's office, come down, take a look, and if you want a copy, we'll email it to you afterwards.
Or visit our website.
But that's the other thing, what if it's on your website?
Right, so if it's on your website,
Or visit our website, give them a link to your website.
and that, yeah,
Individual set of minutes and research.
and that's a good point, because that's information that's already posted on a public website and doesn't require you to take that active step of like sending this email out. So you gave them the link, they can just go get it. I think that offers a little bit more protection when, say, you get this, you know, what is it, Steve? Is it muck rock?
What,
That- what's-
the muck rock.
Yeah, when you get muck rock from Connecticut saying, send me, you know, every police dispatch log for this, whatever, you know, then it's, there's no link that you can just refer them to, or no website. You would have to physically compile that into, you know, an email, attachments or whatever, and send it out. So I think the difference there is kind of helpful.
Kind of a rhetorical question.
Well,
This one?
differently,
Yes,
Sending them a link to that particular document, which is readily accessible on your website, is different than sending them a Word doc, or PDF of the one that's saved on your
Right.
local drive or on your system.
Yeah,
It's a
I mean, you're just
different
directing them
distinction.
where to go, right? That's different than
Right.
like attaching a PDF copy of the minutes from your computer or whatever to the email and sending it out.
There's a metadata component to that.
Okay, so let's go on
do you want to
to
do that one, Jonathan?
joint.
Yeah.
Is this a question?
Yeah, I was just reading.
Okay. All records are for the benefit of all citizens. Just because one person wants to have an archive document to examine and complete an investigation for the purpose of holding their select board accountable for their actions, doesn't that benefit all? So I think this is a question about the fees, because I think this was the same person who asked about, you know, why charge a copy fee if if the copy machine is bought with tax dollars. So, you know, again, it's in the legislature decided that was allowed, that you're allowed to charge a reasonable fee. So, you know, that was something that was passed through the legislature, passed into law. So it's the law, you're allowed to do it.
I mean, I guess I would say to this particular person asking these questions, if a town wants to go ahead and vote not to charge people for copies of documents, or copies of some documents, they're free to do that. That's up, a local town can make that decision. We're just saying, this is what the law allows a town to do, to charge a reasonable expense for the actual cost of producing the copy. But other towns might have a different view of what they're willing to put in their budget for the cost of responding to right to know requests. That's up to the town or the town meeting or the select board.
Right, and that's a good point. The town doesn't have to charge anything if they don't want to, but they are allowed to charge by statute, by law, a reasonable fee. What are we at here? All right, so how much time to produce records? We have 5 days, right? Well, the answer is sort of. Records that are immediately available must be produced within 5 days. But if the records are not immediately available, you have a few different options. You have up to 5 business days to make those records available, provide written acknowledgement of the request and an estimation of the time it will take to produce those records, or provide a written acknowledgement and an explanation of why the request is being denied. And you should ideally cite which exemption you're denying that request under the statute. We talked a little bit about this, the duty to search for records. The agency needs to show that they put in, and the standard is beyond material doubt, that it conducted a search reasonably calculated to uncover the existence of those records. So, you know, that standard beyond material doubt is a standard used in court. You know, there's beyond a reasonable doubt, which is the highest standard, and then you kind of go down from there. So, and this goes to your question, you know, you need to show that you put in a solid effort to find these documents and that the efforts you put in were reasonably calculated to find them. That's important because if you spend 6 hours looking in, you know, a section of the office where these records wouldn't be kept, that's not good enough. You got to show that you put in an actual reasonable effort to find these records. And that's a legitimate reason to say that you can't comply with the 91A request right away. Technically, the record might be immediately available because it exists in the basement of the building, but you need a little bit more time to try to find that record. So it's totally appropriate to provide a response within 5 days that says, we believe this record is available, but we need time to locate it, and you can provide a reasonable amount of time that's going to take you to search for that record.
Can the town get sued if you can't produce it?
I
Is
mean,
it something that should
yes,
have
they
been kept?
can, you know, if it's something that, so, and that's going to get it, we have a section on
Okay.
remedies for that, but, you know, to sort of explain it is that if you respond with a 91A request to say, we can't comply with this, the record, we can't find the record.
Mhm.
Technically, a person could file suit with the court and say that they didn't comply with my request, but if you can show that you put in a reasonable effort to find it and you weren't able to find it, and there's no indication that the record was like maliciously destroyed or something like that, one of the reasons that would result in a remedy, then I think you're going to be okay, you know, as long as you can meet that standard.
Yeah. Somebody requested that there was a policy approved by the budget committee back in the 90s. They wanted to get a copy of it. What if we know where the files are after they pulled out of storage? And what if we can find the 90 in a file box, the minutes of the budget committee from the 90s? Could we just say, here's the box, you can go through and look and see what you want?
So I guess I don't
He's
know.
looking for a policy, but he doesn't have a date.
Okay, so
They approve.
yeah, so I mean, I think this goes to that, you know, one of the first slides, which was that the request needs to be reasonably described so that the municipal employee knows what it is that they're looking for. And so in this instance, you know, and this is a good example. If somebody says, I don't know the exact date, I know it was, you know, sometime in the 90s, it was with this public body, you know, dealing with X, Y, and Z or whatever. if you can produce the box that will likely have that in it, but that's the sort of the closest that you can come with the information provided by the person requesting it, then I think it would be appropriate to say, here's the information that we have that we think comes closest to satisfying your request. You're welcome to go through it. Steve, do you think that's?
Yeah,
appropriate?
actually, there was the recent decision in the Superior Court in Nashville dealing with this, what is sufficiently reasonably described? And there's one way to analyze what is reasonably providing direction to the municipality. And they refer to a federal case where a federal court judge says, well, asking for public records is not like playing Battleship. You don't actually have to say, I want this email that was produced on this date and these were the authors, because you may not know that. But on the other hand, if you can't give some reasonable direction to the agency normally handles records. I want this policy, which is produced by this particular public body, during the month of January, by this particular committee. Well, now that's enough information for me to go find the budget committee file and look in the month of this and go find it. But if I just think that there was a policy adopted by the budget committee sometime in the 1990s, that's impossible to undertake a search for it because there are way too many minutes, too much things to look for. So you have to look at each individual request and make a reasonable judgment. Is that a reasonable description? Can we really go find it in a reasonable period of time, or is it's impossible because it's so broad and it doesn't give us enough direction to go find what the person's looking for? That's where we're left right now, and it's not a perfect answer, but it's what the courts will analyze, trying to decide whether or not you've reasonably taken steps to look for the record.
And that's a New Hampshire court case?
Yes, it's actually on appeal now. It's Mrs. Cowal versus the city of Nashville. And it's a Superior Court decision. And it involves a long-term debate ongoing with her and others complaining about the assessing department of the city of Nashville. And it is currently on appeal to the Supreme Court. Okay. So I can't spell the name Colquhoun, but it's Colquhoun versus the city of Nashville.
Thank you.
If you'd like to spell it, I can give it to you.
So kind of following up with that, and what we're talking about now. So if something is not reasonably described, like what's the town's recourse? Because we've had an abundance of very broad right to know requests from people kind of looking for things that maybe aren't there. Like we had a request requesting all emails from some current and prior board members as well as the town administrator. But those aren't all subject to anybody's review because like things from the town administrator might contain like personnel information or legal information. And there's really no direction. And then when we kind of push back, people say, like, I have a right to know this and I'm a resident and this is why you need to give me everything. Like, I don't know.
I think one thing I would say that, and this is involving a case involving the city of Keene, South Study versus the city of Keene. One of the things the court made clear is that it may be necessary for you to have an interactive process with the requesting party to narrow down the request. So it may be necessary to pick up the phone rather than email and say, what are you really looking for?
Mm-hmm.
Can you give me some better direction? Can you narrow the scope of your request? But the one that you're mentioning, if someone comes in and says, I want all emails sent by and between the town administrator and this select board member during this period of time, they're gonna have to go find those on the server.
Mhm.
And you may then have to spend the time going through which ones are exempt or have to be redacted.
And that's what
That
it's kind
seems reasonably described.
It's just frustrating, I think, like that there's no recourse that we can't charge like administrative fees because like if the town attorney or the town administrator has to go through.
They have to go through them, but it doesn't mean you have to drop everything else you're doing to go do that. So what I always say is, okay, you can reasonably allocate an hour a week to the project.
Okay, so there's no real definitive, like if we tell them that and
It's going to take 6 months for us to go through
Okay.
these and give you a response, and we'll try to give you interim disclosures. That's okay.
Okay,
But someone has to keep track of, okay, we told them 6 months that we're working on it and then do an appropriate follow-up. Don't let it fall through the cracks. That's where you get in trouble.
okay, thank you.
And I have a virtual question. May a citizen take photos of documents provided by the town while going through the materials provided? Yes, I think that's appropriate.
Yeah.
They can, if they want to take their smartphone and take pictures of each page instead of making a photocopy, I don't think that there's anything wrong.
But make sure you're not just making that box full of stuff that might contain confidential information. You may need to
Right.
be cautious with what you allow someone to leak through. But if they're just board meeting minutes, well, that's public record and doubt there to be anything private in there.
Another thing is if you're providing an active file, also paying attention, because things can end up in files that weren't originally in the files. We had that with great development question that came up.
Thank you.
Yeah, so it's always important anytime you're disclosing any information under right to know to make sure that some ancillary stuff that maybe wasn't part of the initial request, but is being included on the document, that you're not accidentally disclosing other information that should have been redacted. So this next slide is sort of what we've been talking about. NHMA has a couple suggested reasons to provide for the delay if you can't produce a record immediately, that you need time to determine whether or not the record exists. You need time to determine whether or not it is disclosable under 91A. And if it is disclosable, you may need to determine how much time it will take to do the requested review for potential redactions and copying or something like that. So now we're going to move on to record retention policies and potential remedies for violations of 91A. So record retention, there's a statute on this. It's RSA 33-A3. This is the statute that sort of outlines the retention policies and the timetable for retaining, almost every type of government record you can think of. The municipal officers, so it also establishes a committee. RSA 33A3 establishes a committee for the oversight of record retention. It says the municipal officers or their designees, together with the clerk, the treasurer, and assessor and tax collector of each city or town, shall constitute a committee to govern the disposition of municipal records pursuant to this chapter. Unless otherwise provided by municipal ordinance, the committee shall designate the office responsible for the retention of each type of record created for the municipality. This committee, this is a statutorily designated committee of people who are in charge of making sure that the town is complying with its record retention policies. There's a section in there, section 5 on microfilming. It says that if municipal records are disposed of by microfilming, 2 films shall be produced. 1 film shall be retained by the municipality in a fireproof container and properly labeled, and 1 shall be transferred to a suitable location for permanent storage. And then there's also a timetable included in here under RSA 33A5-A. At least once every 5 years from the date of creation, the municipal committee shall review documents and procedures for compliance with the guidance issued by the Secretary of State and the Municipal Records Board. So that's an ongoing process of making sure that you're complying with that. There's also a note on electronically archived records. The statute says that any municipal record in paper form that's listed in RSA 33A3 may be transferred to an electronic format, but it must be in PDF or PDF-A format. And the original paper records may be disposed of once the record is properly backed up in the correct electronic format.
Except no getting rid of original city council, town meeting, and select board minutes. Those are permanent and must always be retained. They cannot be converted to PDF-A. That's the exception.
Is there a number of years, like you gotta wait 5 years and then you can convert them to PDF?
No,
Not for, well, other than
If you have
what-
to keep it longer than 10 years, then.
no, the statute doesn't have that requirement anymore. There is,
Oh, yeah, I gotta
you can go directly to PDF-A if you want to.
Oh.
That's what the statute says.
and then you can immediately then destroy the paper records. You don't have to hold the paper records for a period of time once they've been.
Can you repeat that again?
The statute permits the town
Yes.
to take any record that is required to be retained regardless of its retention period and convert it to a PDF-A document and save that instead of keeping the paper record. That's what the statute now permits.
So all of the select board meeting minutes that we have.
No,
Except the
I mean, not
except
select board,
those.
yes.
Yeah, those are
So
not,
planning board, zoning board, all of those, we could scan all those.
yes.
Electronically, and get rid of all those notebooks.
You could get, you don't have to retain them anymore. That's what the statutory change that was.
Select board's the only one that you have to keep.
Governing bodies, basically, it's the governing body and the town meeting.
Yep.
The governing body holds obviously aldermen and select boards and council.
Right.
So
But
that's,
minutes of the ZBA, minutes of the planning board.
those
could
can be converted to PDFA and you're allowed to retain them in a PDFA format. But remember, it's PDFA means /archive. It's a specific setting you have to save it in. Sometimes it's not available in your older Word versions. You might have to have Adobe Acrobat to do that.
You have a question?
Yes, so I'm new to the town that I went to. A little over a year ago, the town hall had burned down. And we have a storage container that was filled with any documents, furniture that was salvageable, if you will. And so what if we're gonna be starting to go through a lot of the documentation in that storage container? And again, it has meeting minutes, any documents that were in the old town hall. What if we're going through there and we can't obtain all of those records because they were lost in the fire? What happens then?
I think the reality is, this has happened to many municipalities. I can't tell you how many times I've been told by the towns I've represented, oh, we lost all those records in the fire in the 1960s or whatever. They're gone. There is no remedial action that can be taken. As long as it's, as Jonathan said, not the misdeed or some bad behavior by a municipal official, there's no action that can be taken against the municipality, because this was, an act of God, a force majeure that resulted in the loss of those records. That's just, unfortunately, what has happened, and can't bring them back, and you can't penalize the community in that instance because it was an accidental loss.
So kind of going on to that, what if and I know you had said like the meeting minutes, you have to keep the paper records of it. So what if like we're going through there and there's like water damage to meeting minutes? Are we able to at least get that scanned? Smoke damage, I know that our source container.
Well, I mean, the statute used to have a provision where you could convert certain records to microfiche and microform. I guess I would say probably you should not get rid of anything that is in fact an original meeting minutes of your governing body or town meeting, and recognize that they may not be usable, they may be water damaged, but it's possible that they can be restored in some fashion in the future. So put in a storage mechanism that would allow them to be protected for as long as possible and not get rid of them. I would not dispose of them, and I wouldn't go to the, scanning them. I mean, scanning them might be an interim measure, but you still are going to have to keep the original paper copies, even though they may not appear to be usable. You should retain them. So you may have to do both.
Thank you.
And Steve, we have some questions coming in if you want to start going through those.
Is there a legal definition between record retention committee and public records committee? Well, the statute talks about the municipality having to have a municipal records committee, and automatically the select board and the town clerk are on there. So I don't have the statute right in front of me, but it is considered a municipal records committee. For that same question for Patricia Heinrich, yes, the statute contemplates that automatically a town has a municipal records committee, but at a minimum includes a member of the select board and the town clerk along with others. And finally, there's a question about library trustees also can be converted to PDFA. Yes, all records, municipal records may be, except for, I would not want the library committee minutes. Because the library is kind of a semi-independent organization, I might be inclined to characterize them as similar to the governing body. So I would not want to see their meeting minutes turned to PDFA destroyed. I would keep those. And I think the last one, Jonathan, is that staff to give a time frame for keeping emails.
I think I don't think it has a specific time frame for like all emails. I think it's content based. So it would be the content of the email would fall under one of the categories that would then have a time frame of how long you need to hold on to it.
So there is a set of criteria for retaining correspondence. And so there are 3 of them in there. So you really have to just treat an email as correspondence and then look at the correspondence section of the retention statute 33-A:3-A and retain for the periods as described there as applied to correspondence. That email is just deemed to be correspondence.
Just attachments is not correspondence, so it's could be anything in there.
Right,
Actually, it's the
right.
email is just a vehicle, not a.
Yeah, and it's I don't think there's not, it doesn't have its own line under the retention statute. Okay, so for deletion of electronic governmental records, we talked a little bit about destroying when records can be destroyed. So when a record is legally allowed to be destroyed, you can delete the electronic version of it if it's held electronically. Just a note on deletion of records though, a record is not deleted unless it's really deleted. So sitting in your recycle bin is not a deleted record. And so if you intended to delete it, but didn't actually remove it in all of its electronic formats, and somebody files a right to know request for that record, you have to provide that record. So make sure that when you're hitting delete, you're then emptying the recycle bin or whatever you need to do to make sure that that record no longer exists. Beverly has another question. Please clarify. Okay, Steve's gonna type that answer to you. So violations, how are violations of RSA chapter 91A enforced? So there's no state agency currently with the power to enforce violations of the right to know law. All alleged violations of RSA 91A need to be adjudicated in court. So under RSA 91A:7, any person who is aggrieved by a violation of this chapter may petition the Superior Court for injunctive relief. Just a note on that language, any person aggrieved by a violation of this chapter, when we were talking about the Provenza case, the police officer who claimed that he didn't want the town to release the report, there was a stance taken by the newspaper that Mr. Provenza was not technically an aggrieved party under RSA 91-A:7 upon the appeal of that decision. And the court sort of punted that question. They didn't specifically address who is or isn't an aggrieved party to a particular right to know request, but for our purposes, I think that it can be interpreted pretty broadly that if you are somebody who could have had a privacy concern that would be violated, or if you are someone making the request that's being denied that information and you were the requesting party, I think you fall under that aggrieved person in most instances. And so the statute also provides that if it appears from the petition filed in court that the time is probably of the essence, the judge may order notice by any reasonable means, and that the judge has the authority to issue an order ex parte when he or she shall reasonably deem that such an order necessary to ensure compliance with the right to know law. So a judge can intervene if there's a reason for expediency that this document may or may not be needed immediately. The judge does have the authority to intervene and take that action. So what are the remedies if a court does find that a town violated RSA 91A? So one of those could be attorney's fees and costs. Attorney's fees and costs are not automatically awarded under all circumstances. It requires sort of a little bit of extenuating circumstances, but RSA 91A:8 requires the payment of attorney's fees when both of the following are true. So first, the court finds that the lawsuit was necessary in order to force the municipality to comply with the law that they should have been complying with in the first place. And two, that the public body, public agency, or person knew or should have known that the conduct engaged in was a violation of right to know. And so that's another one of those legal terms, knew or should have known. It's essentially like a negligence standard that if it was obvious enough that this record should have been disclosed and that the municipality refused to disclose it, the court may find that you knew or should have known that this document should have been disclosed. What that means is that if there's a reasonable enough argument that this document may not be disclosable, you're likely not going to meet that standard where the judge is going to issue attorney's fees. So it all comes down to reasonableness. That's sort of what these judgment calls always come down to. But if you can reasonably articulate an area of the statute, an exemption or something like that, as to why you think that this document shouldn't have been disclosed, then that's likely going to protect you from an attorney's fees ruling. But if it's something, if you're refusing to provide minutes or something like that, the court's going to find that you knew or should have known that those were disclosable under RSA 91A, or something that falls under one of the things that we talked about that are explicitly stated in the statute, like an employee salary or something like that. Those are things that you should know are disclosable and it shouldn't come to legal action to get you to comply with those. Costs alone are awarded when the first part of the test is established. So what that means is that the costs of bringing the lawsuit absent attorney's fees can be issued if the court determines that it was necessary for their intervention to force the municipality to provide the document, but not necessarily attorney's fees. You need both prongs for attorney's fees. So under RSA 91A9, that deals with the knowing destruction of materials. So a person could be guilty of a misdemeanor if he or she knowingly destroys information with the purpose of preventing the information from being inspected or disclosed in response to a request under 91A. If disclosure of the requested information has been denied as exempt, the public body or agency also has an obligation to preserve that information for at least 90 days, or if there's a pending lawsuit regarding the requested information, to preserve the information for the pendency of the lawsuit. So someone's seeking that record and you deny that record, and a week later it happens to reach its 10-year time period where you can destroy it, you can't destroy it. You got to hold on to it for at least 90 days, or if there's obviously a pending lawsuit arguing whether or not that should be disclosed, you got to hold on to it for the pendency of that lawsuit before you can legally dispose of it. So we have some main takeaways here from what we've been talking about. That's every citizen can request records. Again, that's an asterisk under citizen because we don't have a set in stone definition of that. But for now, we recommend considering anybody who's willing to show up in person and view those records to be a citizen, and you should comply with a valid 91A request that they may make. Records need to be reasonably described. A search for records must be reasonably calculated to uncover the relevant documents. There is no obligation to compile records or to cross-reference or assemble records. Require a citizen to make appointments. That's permitted, and we recommend that. When you are denying public access to records, it's important to provide reasons, and the best reasons are the ones in the statute. So if you can cite the statute and say, we are denying your request under RSA Section 5, paragraph 4 for the privacy exemption, that's the best way to do it because you're telling that person exactly why their request is being denied. Always make sure to redact exempted information. You can charge reasonable fees for providing copies, and make sure that things are actually deleted if you are deleting them. So that concludes my section. Do we have any other questions related to
I don't
this?
see any further questions, but we will certainly invite those who are participating remotely to submit any further questions they have. We have one more. Questions, I'm too unclear about this issue. Mine was the library trustee question. I'm still wondering if committee minutes can be only held as PFAs. It would be clear up an entire shelf in our library record reading room. And what I said was, I think that because the library trustees are more like a semi-independent and autonomous governing body the better practice is to retain them. But I also have put in the chat the governing statute. And I'll repeat what that governing statute says. It says, and this is RSA 33-8:6, notwithstanding any other provision hereof, which includes this ability to save things in PDF only, a regional town meeting of city council records shall not be disposed of until be permanently preserved. What does that mean? Well, that's referring to, in a city, the legislative body is the city council. In a town, the legislative body is the town meeting. So technically, under the law, I'm telling you, it's only required to keep permanently the original actions of your legislative body, town meeting and town and city council. However, I'm also saying, as a matter of policy, I think it's a better practice to also retain the permanent meeting minutes of your governing bodies. And in a town, there are two kind of governing bodies. The library is the governing body of your library, and your select board is the governing body of the town. So I would recommend, but I would defer to the statute. Technically, the statute only requires permanent retention of legislative body actions. And that's probably the best answer I can give.
So if you've noticed a theme with RSA 91A, it's that everybody wants a yes, no answer, and the answer is always, it depends. And that's the case with a lot of these things, and with the advice that we give at NHMA, and that really all attorneys give, is that we're always going to advise you to play it on the safe side. So when there's a gray area, whether or not, for example, the library trustees minutes, fall within this definition, our best advice is always going to be the one, well, if there's a chance that they do, then we suggest that you treat them as such. So that doesn't, the statute is not explicit. It does not explicitly say that these library, minutes need to be kept the same as the select board, but I think there's an argument that you could make that they are akin to the select board minutes. And so it's the best practice, but it's up to the town whether or not you want to.
Right, and it's up
See
to
it
the
the same
municipal
way.
records committee. That's part of the reason why you're supposed to have a municipal records committee to help manage and make these decisions and set these policies. And I know that not all towns have an active municipal records committee, but it's a good idea to do it and then maybe set some of these policies so that this is well known to all your public bodies and public officials.
All right, so seeing no other questions, I think that
We can say we're done.
concludes. So thank you everyone for attending, both in person and virtually. I hope that this has been informative and hopefully answered some questions more definitively than others that you may have had for 91A. And again, Steve and I are always available through the legal inquiries function, whether email or call, to answer questions, specific questions that come up, and we'll do our best to answer them. So thanks.
And if you don't know her, I'm going to let Ashley Methach, who's our events coordinator, say a few words, because she's the person behind the screen who does all of the work that makes all this stuff happen. So Ashley.
Yeah, so I just wanted to let you all know, I think that I had mentioned it earlier and some of you were in the room, and for those folks of you at home, just so you're all aware that after this workshop is over, I have been recording it, so I will be sending a copy of the recording to each of you. It'll be a YouTube link, so you'll have access to it for like ever, as long as you keep my email. And you can share it with other folks in your municipality. And I will also be sending the evaluation, which I sent ahead of time. Please fill that out. This is our first hybrid workshop, so be interested to hear how y'all thought it went, and given the fact that there were some people at home that we had to answer questions for, and same thing with the folks at home, please fill out the evaluation, and along with the recording and the evaluation, you'll get your certificate of attendance and a copy of the materials again. And you can always reach me at the New Hampshire registrations email box should you have any further questions. Thank you for joining.
Thank you. Very important.
Thank you.
All right.